Welcome to the Ada K Show. I'm your host, Ada K, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. And don't forget, comment, like, and subscribe. And if you love this channel, please become a member. Good morning, everybody. How are you doing? Yes, I slept so good last night. It was like, I don't want to get up this morning, but I got up. I slept so good. I hope you guys had a good night, slept well too. Well, today is going to be an interesting day because we have trials resting before we were prepared for them to rest. We've had a few shockers yesterday. It was a good day. Allergies are still rolling. Y'all need to be in prayer for some of us states, Texas, all the way up to Tennessee. We're getting ready to get they're saying the worst ice storm in 10 years. I don't know about that. We'll see how bad it gets for us, but we are weatherizing ahead of time. So there is a small chance if I do not have power, we will not be going live on Monday morning. The last time we had a massive ice storm, snowstorm, we lost power for a week. So let's pray that doesn't happen again. It's like being in YouTube jail. By the way, there's a certain person in YouTube that loves lead shooters, and he showed a air lead shooter live last night, and he got taken down. I knew it was going to happen. I was like, dude, you're pushing the boundaries. Oh, I was so enjoying his recap. Okay. Speaking of recaps, I'll get my allergy meds on board shortly. Ooh, trying not to sneeze. Okay, I'm back. So yesterday marked a major turning point in the trial. Both the prosecution and the defense officially rested, closing out 10 days of emotional, contentious, and often explosive testimony. I got to say, I was honestly surprised. I thought we were going to be going at least another week with the defense's side, and they put on, I think, 2 witnesses yesterday. I'm like, duh, that ain't good. That's a no bueno. We'll see how it works for him. The courtroom energy was shifting greatly from fact-finding to looming battle of closing arguments. And so the state's case concluded with 35 witnesses and 9 days of testimony. The court arguments were as follows. Yes, I actually pulled my notes. I think the court arguments are going to be the following. First on scene, Gonzales failed to delay or stop the red rumor. Gonzales. His inaction I thought I was going to sneeze again. Because of his inaction, he's got child endangerment and abandonment charges for all 29 children, 19 unalived and 10 injured. Now we have the teachers and parents described the terror inside the school and the agony of waiting outside with help that never came. Excuse me. Texas Rangers Lieutenant Nick Hill became a flashpoint during cross-examination, leading very heated exchanges between the attorneys. We may rewatch some of his testimony on Verdict Watch if both trials are on Verdict Watch, because that testimony is the core to the prosecution side. The courtroom, oh my gosh, the tension, y'all, you could cut it with a knife. Judge Sid Harrell issued multiple warnings on both sides, whose tempers were flaring. At one point, the victim family member had to be escorted out, yelling at the witnesses inside the courtroom. Now, the defense side, they rested. They claimed tunnel vision and human factor. Their main arguments: Gonzales experienced an inattentive blindness and tunnel vision during the chaos and during the active lead shooter event. The psychological response can severely impair perception and his decision-making abilities. The former San Antonio police officer testified to the jurors that may not grasp how extreme tunnel vision actually can be. And I got a gnat driving me crazy. I got Mama texting me. Okay, and then the defense's strategy. Well, they were reframing Gonzales as not negligent, but a human being overwhelmed by a catastrophic, rapidly evolving situation. Argued that criminalizing human psychological response set a dangerous precedent for all first responders, and then they rested. Judge Harrell gave the instructions at the end of the day after resting yesterday. The state position is going into closing most likely will be, and I thought about this a lot. Where are they going to go? I think they're going to keep hammering on the inaction, and they're going to keep hammering on the fact that he had a weapon, they had opportunity, and he had the training, and he didn't proceed, and thus children die while he stood outside. I think the defense is going to sit here and claim that Gonzales' perception and was psychologically compromised, as they call it, and he did not choose inaction. He was overwhelmed. Criminal charges for human error in a crisis are unprecedented, and that is very true in this. And they think it's unfair, and other people do too. Not everybody agrees with that. He should be charged. So we'll see where the jurors agree. Good morning, honey. Good morning, Miss June. Okay. Are y'all ready to get into trial? Dun, 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 dun. All right, let's get into trial. I've been waiting. Well, we're still waiting. Okay. Let me get my banner up. I don't know why it disappeared. Things are disappearing. And guess what, y'all? We ordering my glasses today. Thanks to Miss Angela. She turned me onto a fabulous page. When I get my glasses, if they are what I expect, then I will tell everybody who that is, because my eyeglasses went to a store here who I've gone to for years, a doctor's office / store, and just the lenses alone, y'all, were going to be $1,200. $1,200. Well, they are more than half of that off. They're about 60% or more less than what the store was going to. And that's for frames and lenses. So this chick needs bifocal. So I will let y'all know. I'm excited. And I know I sit here and I look like I'm upset or mean, because I'm squinting to see. I can't wait till I can look at everybody, because when I don't squint. Everything's blurry. So, I'll let you know how it goes. I'll let you know how long it takes to get them, and I'll let you know how they go. Because if my mod can save me almost 60 to 70%, I'm sharing it. Hello, honey. Good morning. I have not really checked out my girl yet. I will check her out in a little bit. Miss Honey and I play Animal Crossing, and she gave me a villager, and it's a monkey. I wanted to show Miss June, but I didn't. Yeah, but it's in the game. Oh my God, why is that doing it too? The other one did it too. Looks like the judge is coming in the courtroom. The judge is coming into the courtroom, I think, or somebody came in the courtroom because that came from the judge's chambers. It may have been his clerk. But I am so excited to finally get in glasses and being able to see. I don't understand why the people, if these, and they're the same lenses, by the way, just FYI, the same lenses. They may be a different name, but the same of everything. And I'm like, why are they so much cheaper? We'll find out. Give thanks to the Lord, for he is good, for his steadfast love endures forever. Psalms 136:1. That just popped up on my screen. I guess somebody thought I needed Psalms 36:1 today. We'll see. Good morning, Miss Bonnie. Good morning, Miss Bonnie from Facebook. We are following a horrendous trial, Miss Bonnie. It is the Uvalde police, the Uvalde unaliving, and it is the police assistant chief who is on trial for 29 counts of endangerment of children. 19 passed away. 10 of them were injured. Okay, thank you so much, June. And so, anyway, we're waiting for that. We are going to take a little pause here with this one because I am dual trialing today, y'all. So I have got to go, and the other trial has started, and I need to go and log in and get that one up and going. So give me a minute. We're going to go in and wake up that trial. June, that wasn't supposed to start till 9 a.m. Why are they starting early? And this one is running late. That's the way it goes, I guess. Miss Bonnie, I drove by your house the other day. I hope I saw that y'all were working on it. Miss Bonnie in Facebook was one of the poor souls who lost her home to the Kerrville flood. They are continuing to recover. So love and blessings, Miss Bonnie. I love you, dear friend. And I'm going live in the other one. Good to see you, Miss June. Woo! I got the other one going off in my ear. Give me a minute, guys. Good morning, everybody over at the Brandon Banfield, the OPAD trial. Just want to let y'all know that we are going live. I am live on both channels at this moment. So we are trying to get everything lined up here. Everything's wiggling around, and I got to have both of y'all up. I got to have that over there. The Brandfield trial, the prosecution has rested. June, did the defense rest too? I slept. I'm having a brain fog. I think the defense rested as well. Or they're going to, or they will today. It's predicted that they will today. So we are going to be going, oh, well, are they live, June? Do we have court in there? Oh, where did it go? Come on. Everything's all wiggling around over here. So in the au pair trial, the homeowner, the father, the couple hired this woman to be their au pair, and unfortunately, in the end, the au pair and the husband hooked up together. They're not live yet, but they're getting there. They hooked up together, and long story short, they red roomed the wife. So we have an au pair red room trial that's getting ready to start. We have the Brandon, that's a Brandon Banfield. And then we also now have the Gonzales trial that we are also waiting to go live. So guys, it is going to be another day of dueling lives. That it will be. And I'm setting up my monitors, forgive me, because this requires a lot of windows to order to pull this off. So patience, please. Okay, so on day 11 in the Uvalde school lead shooting with Mr. Gonzales being charged, they're going to be doing closing arguments. Well, jury instruction, closing arguments, and verdict watch. In this day today, in this case, the defense's case in chief begins. I don't expect to take it. From what I understand, they don't expect to take long, but God only knows. There was the defense begins today. A frantic 911 call leads police to Banfield home, where Christine Banfield was found fatally. I can't say the word, by Joseph Ryan, who was supposedly by Joseph Ryan, who has now been found unalived as well. The investigators later uncovered the affair between Brendan Banfield and the family au pair Julia Magalis, and the alleged plot to lure Ryan to the house under the ruse of violent actual encounters. And yes, Magalis has pled guilty to manslaughter and later told prosecutors the scheme orchestrated by Banfield to avoid a divorce. So what happened there? You have a man and a woman who are married who hire an au pair. And the au pair and the husband start having an affair. And then they decide to unalive the wife because they did not want to stop the affair. So they decided to register the wife on an actually explicit website for BDSM. And they decided to use her name and create an email and to lure a man to the house under the ruse of EPAR fantasy. And he goes over there to the house with a knife, thinking that he's going to have a very explicit actual encounter, only to turn out that he gets shot and unalived in a plot to murder him and the wife. So the au pair and the husband to continue their affair. Mary, hello, Mary. Good to see you, beloved. Thank you for joining me in the au pair. And Diane, I'm still loving my mug. Miss Diane bought me that for Christmas. And I absolutely adore it. She's such a great friend. Everybody on Facebook, thank you so much for joining. Everybody on X, thank you so much for joining. We love and appreciate you. Hope y'all are having a fabulous day. One sunny day. Where's one sunny day? We don't see Miss One Sunny Day here this morning. Okay, I gotta pop out my chats. I can't do that until I go. I could have done it before, but pop out chats. Do you know what, Miss June? I forgot to do something last night. Can you double check and make sure we're monetized? I forgot. Sorry. I kind of decided to sit down on my bed and fall asleep. I don't know what happened. It overcame me last night. I got so tired that I sat down on my bed and fell asleep. Y'all, it was interesting. Woke up a couple hours later, felt like I'd sawed 20,000 logs. It felt great. Then I decided, okay, now I need to really go to bed. So that's when I decided that I needed to actually go to bed. And I did. So it was interesting. I went shopping last night with my dear friend, Miss Linda. Miss Linda. She doesn't watch TV. Let me shut my door real quick because the monkey butt hears me. And we got this shirt. But look at the pants, y'all. Look, they got sparkly. Yes, I got new pants. I got sparkly. I love it. All right, guys, we're set up. We're ready to go. I got chats popped out. So, Mary, thank you for joining. I hope you're having a fabulous morning. And okay, both cases are up and running. Both cases were waiting to go live. I you know what? I knew it. I knew this was going to happen, especially since we've been going live at 8:30 every morning. Well, yesterday at least, this week. Yesterday we went live at 8:30 in the Adrian Gonzales, and I thought they were supposed to go live at 8:30 again. I crawl out of bed. Y'all, one thing about having these really cold days, it is so hard to hop out of bed. So hard to hop out of bed, y'all. I have a heated mattress pad on my bed. So my bed is toasty all night long. And for me to get out of my bed after I slept like a rock is so hard, y'all. Hence why coffee is a good thing in the morning. My gold mug. In my gold mug. Okay. Sorry, got a little email there. Okay, coffee and mod love. Thank you so much, Miss Honey. Yes. And I got to tell you, I still do not know who paid and shipped me from Amazon. And I wish I could find out who you were. But obviously, you don't want me to know. So I'm going to thank you anyway, publicly. A coffee cup mug warmer. It's a little plate that's like a little mini hot plate. Put your coffee cup on. Y'all. It is the bomb. It is the bomb. The bomb. It keeps your coffee to your perfect temperature. I think it has like 4 different temperature settings on it, from lukewarm to very hot. Oh my God. Problem is I drink more coffee with it. And I think yesterday I drank a double shot. All of a sudden things were going a little weird in my head. Don't do that again. Don't do double shots again. Okay, so guys, I'm sorry. We are still waiting, patiently waiting for court to begin. I want to show Miss June, because Miss June loves monkey butt. Miss June loves my monkey butt, and Miss June disappeared. Miss June, are you okay? You're not there anymore. I was going to go find monkey butt and show you monkey butt in my game. I wanted you to see monkey butt. I was going to go find monkey butt and show her my monkey that Honey gave me. I wish it could show you where they were. Let me see, where's her house? Let me see which house she moved into. Monkey. Oh, just a monkey butt. I better be careful talking like that because my monkey hears me. She's going to get mad because I'm not over there loving on her. I explained to somebody the other day that I have a monkey, and they were upset because they want a monkey. I'm like, yeah, well, monkeys are great, but anyway, she's out running around. We'll find her. I hope everybody is staying warm. Guys, please prepare properly for this horrible freeze that we are going to be having. And I found monkey butt. I found monkey butt. I found monkey butt. Okay, let me go grab her so we can say hey. Hey, and that's the other monkey. Sorry, I have two monkeys on there. That's not her. I just got this other villager too. He's a male monkey, but he's got this mask on him, and he makes me feel creepy. It feels real creepy. I'll be honest. I don't like anybody with a mask on. They creep me out. I guess old childhood trauma. All right, guys. So we are getting ready to go live as soon as any one of the courts decide to go live. We had one court that was supposed to be live at 8:30. That is still not live. We have another live that was supposed to be live at 9. They're not live, which is a surprise because both of these courts are usually right on time and very much so a stickler for being on time. They're not here yet. Go figure. Where's my monkey girl? I have to go to the store for milk and bread and eggs. Yeah, go to the store. If you're in this free zone, go get your stuff now. I went last night after we got off a live, which, it was kind of nice that we got off a little early so I could see sunlight. This is what I hate about this time of year is the lack of sunlight. I hate it. We've been lucky so far to have a lot of light, but I miss the sun. Even coming in just through the window on the gray days, it's depressing. I don't like winter at all. Okay, it looks like the Branfield au pair trial is coming into play. They are starting. Let me get the court feed up. Now, mind you, this is the same judge, just so you guys know. This is the same judge as was in that served on the bench for the Karen Reed, not the Karen Reed, Amber Heard and Johnny Depp trial. Yes, same woman, same judge, and you barely heard her in this trial. I'll put this on until the other comes on. Shoot.
Your Honor, this is a motion to dismiss the trial pursuant to due process requirements of the 14th Amendment of the United States Constitution. For the Commonwealth's knowing use of false testimony tainted the trial and must be dismissed pursuant to NAPU versus Illinois. I have the cases, Judge, and I can submit those to you. I've given some to counsel. Unlike a motion to strike where we're talking about the sufficiency of the evidence, now the defense is making a motion to dismiss under NAPU versus Illinois. This is incumbent upon the moment that you realize what the violation is. And as of yesterday, when the Commonwealth closed with no detectives, with no evidence relating to the digital forensics, no evidence relating to the catfish, which has been what they've said all along. It was at that point when they rested that this became incumbent upon me to make this motion. Usually this motion is made in conjunction with a Brady request that's not complied with. It stands for the proposition that if the government knowingly uses false testimony, the trial is tainted, not just for credibility issues, and must be dismissed. In this case, and actually in Napu, the government failed to correct the testimony of a witness co-defendant who stated he was given nothing in exchange for his testimony when the prosecutor knew he was to receive favorable treatment from the sentencing court. This knowing falsity was enough to taint the trial, requiring reversal. For this, a bit of background is required. In September, the Commonwealth gave me a list of probably 65 witnesses. That was the last filed witness list with, that was probably when Mr. Kleen was still on the case. There was no, pursuant to the discovery order, any witness list filed for the Commonwealth. It was only when I reached out that I was able to get a list of some names that they potentially might be using, of which Detective Miller, who's the digital forensic detective, was not on there, nor was Detective Bryant. In fact, there were very few police witnesses other than Detective Leach, who we did hear from. As the court notes, you've had this case from the beginning. You've seen the battles for Brady material, which we know were violated because ultimately what came was concluded to be Brady and was known to the Commonwealth back in November of 2024. In fact, even before that. Speaking specifically as to the things that were known or should have been known, is Detective Miller, for Fairfax County digital forensic expert at the time, did an executive summary that was in the October timeframe. In that, he says that Christine Banfield, he concluded that Christine Banfield never lost control of her devices. And it was she who was reaching out to Mr. Ryan and others on BDSM websites, thus thwarting the theory that the defendant was part of a catfishing scheme to lure Mr. Ryan to the Banfield home to set up a double murder. Detective Miller's report was sent to be peer-reviewed as the chain of command did not like its findings. That peer review was concluded and they concurred with Detective Miller's report. This was known a year before Mr. Banfield's arrest and coincided with Juliana Perez Magalhaes' arrest. During the almost 1 year that Juliana remained in jail, Juliana's counsel requested 2 continuances and never secured a digital forensic scientist. And it's unknown if he knew about Detective Miller's conclusions at the time that he decided to take to advise his client to take the actions that she's taken. When the co-defendant decided to accept the reduced plea for time served and her mother counseled her to take the plea and blame it all on Brendan, there was a highly unusual event for Fairfax County wherein the lead prosecutor for this case, Eric Klingon, questioned and interviewed Juliana in the presence of her counsel and some police detectives. In that video interview, she gave a statement in which multiple occasions of her version did not line up with digital forensics and could not have occurred. Detective Miller was then pressured by the detectives in the case to alter his findings to fit Juliana's story, to which he declined and prepared his summary for the homicide unit. He was then transferred without a request to the child exploitation unit. It can be concluded that as of October 2024, the police and the Commonwealth attorneys knew the evidence did not support the catfishing theory. When in October 2025, when she gave her first recant, there were police and prosecutors in there, yet the prosecutor was the one that was questioning. The absolute unprecedented upheaval of the homicide division has been well documented and is directly related to this catfishing theory that was pushed upon and also by the unsupported evidence. At the defense motion for bill of particulars in September, the court asked, is this still a viable alternative for the Commonwealth to prove catfishing? And the Commonwealth committed to that. However, as the evidence ends yesterday, Judge, we have nothing but Juliana Perez Magalhaes. That's, as to the motion to strike, I understand the court's position, but these findings and the evidence to support the finding that the Commonwealth knew or should have known is it within every aspect of this case at this point. This is essentially a lack of candor issue, Judge, with the court, and it's in violation of Virginia State Bar Rule 3, which requires candor with the court. Rule 3.8 requires the Commonwealth be the minister of justice, not just an advocate. Further, 3.8 requires the prosecutor to withhold indictment if there is no probable cause. At the time of Mr. Banfield's indictment, the police knew about Detective Miller's findings, and Ms. Perez-Magalhaes had not changed her story and accepted the Commonwealth's plea deal. These ethical requirements have not been met. But more troubling is the presentation of false evidence by the co-defendant. It is analogous to a prosecutor presenting the testimony of a victim in a rape case, knowing the DNA exonerates them, but doesn't present it. This known falsity denies the defendant a fair trial. This should be dismissed pursuant to NAPU versus Illinois as violator of the 14th Amendment. And there are additional cases, Judge, which I have for your review, which are closely aligned with NAPU, which is the seminal case.
Yeah, I'm familiar with those cases. Thank you, Mr. Carroll. If you want to,
Would you?
that's fine. Yes, ma'am.
Thank you.
Thank you.
Your Honor, counsel has highlighted the Commonwealth's witness list containing 65 people, most of whom we did not call. I expect the same to be true of defense, and that is the nature of a case. When we want to make sure that we do not limit ourselves should evidence be required, we list a witness on that witness list, which is provided to the court well in advance of trial. In this matter, we call the witnesses that we believe presented the evidence clearly to the jury. We have presented the physical evidence collected, we've presented the DNA analysis, we've presented the blood evidence, and there is no requirement that we call a lead detective to present a narrative when we in fact have the person who was in.
Okay, both trials are there and ready to go. For some reason, it won't let me share the other one like it should. Come on. Let me get it up and running the hard way. Brendan Banfield. And let me switch over here. They don't number these, so I don't know which screen will pop up when I do this, or we're going to do it the old school way. Okay, both courts are now in session, y'all.
Good morning, members of the jury. We have finalized the charge of the court. I'm going to read it to you. You don't need to memorize anything. You will have a copy of it, and it'll be in the jury room during your deliberations to consult. After I complete my reading of the charge, both sides will argue the case, and then we will ask you to deliberate. This is cause number 25 FC 0001U. State of Texas versus Adrian Gonzales, charge of the court, members of the jury. The defendant, Adrian Gonzales, is accused of 29 counts of endangering a child. The defendant has pleaded not guilty. You have heard all of the evidence that will be admitted as to whether the defendant has been proven to be guilty of these offenses in violation of the Texas Penal Code. Both sides will soon present final arguments. Before they do so, I must now give you the instructions you must follow in deciding whether the defendant has been proven to be guilty or not. You will have a written copy of these instructions to take with you and to use during your deliberations. First, and I will note, ladies and gentlemen, the notes you've taken throughout the trial, the bailiff will hold those for you until after the deliberations are complete. As I told you, if we have a dispute as to anything regarding the evidence, we're going to rely on the official court record, so the notes will be retained during your deliberations. First, I will inform you of the general principles of law that must govern your decision in the case. Then I will inform you about the specific law applicable to this case. Finally, I will instruct you on the rules that must control your deliberations. General principles, the indictment. The indictment is not evidence of guilt. The indictment is only a document required to bring the case before you. The indictment cannot be considered in any way by the jury. Do not consider the fact that the defendant may have been arrested, confined, or indicted, or otherwise charged. You may not draw any inference of guilt from any of these circumstances. Presumption of innocence. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. The law does not require a defendant to prove his innocence or to produce any evidence at all unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt. After a careful and impartial consideration of all of the evidence in the case, the presumption of innocence alone is sufficient to acquit the defendant. Burden of proof. The burden of proof throughout the trial is always on the state. The defendant does not have the burden to prove anything. The state must prove every element of the offense beyond a reasonable doubt to establish the guilt for the offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If the state does not prove every element of the offense beyond a reasonable doubt, then you must find the defendant not guilty. If, after you have considered all of the evidence and these instructions, you have a reasonable doubt as to whether the defendant is guilty, you must find the defendant not guilty. Jury as the fact finder. As the jurors, you must review the evidence and determine the facts and what they prove. You judge the credibility of the witnesses and what weight to give their testimony. In judging the facts and the credibility of the witnesses, you must apply the law as provided in these instructions. Evidence. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only the evidence to reach your decision. You must not consider, discuss, nor mention anything that is not in evidence in the trial. You must not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by lawyers are not evidence. Evidence consists of the testimony of the witnesses, materials, and physical items that were admitted into evidence. Nothing the judge has said or done in this case should be considered by you as an opinion about the facts of the case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are to be given special meanings. In that case, you should give those terms the meanings provided in these instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and the evidence that are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the evidence. You are to render a fair and impartial verdict based upon the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice or sympathy. You are admitted exhibits. You will be provided all of the admitted exhibits for your examination in the jury room. Testimony. The court will allow testimony to be read back to the jury only if the jury, in a writing signed by the foreperson or presiding juror, number one, states that it has a disagreement about a specific statement of a witness or a particular point in dispute, and number two, identifies the name of the witness who made the statement. The verdict. The law requires that you must render a verdict of either guilty or not guilty. The verdict of not guilty simply means the state's evidence did not prove the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on the verdict. When you reach a verdict, the foreman or presiding juror should notify the court. The defendant's right to remain silent. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf if he elects to do so. The defendant may also choose not to testify. The defendant's decision not to testify cannot and must not be held against him, and it is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. Instructions on count 1, endangering a child. Excuse me. Accusation. The state accuses the defendant of having committed the offense of count 1, endangering a child. Specifically, the accusation is that the defendant, as a peace officer for the Uvalde Consolidated Independent School District, by omission, intentionally, knowingly, recklessly, or with criminal negligence, placed Jose Manuel Flores Jr., a child younger than 15 years of age, in imminent danger of death, serious bodily injury, or physical or mental impairment by engaging in one or more of the following omissions. A, after hearing gunshots and after being advised of the general location of the shooter by witness 1 and having the time to respond to the shooter, the defendant failed to engage, distract, or delay the shooter, or failed to attempt to engage, distract, and delay the shooter, or failed to otherwise act in a way to impede the shooter until the shooter entered rooms 111 and 112 of Robb Elementary School and shot at a child or children in rooms 111 and 112. B, after hearing gunshots and after being advised of the general location of the shooter by witness 1 and having time to respond to the shooter, the defendant failed to follow his active shooter training to respond to gunfire by advancing toward the gunfire until after the active shooter shot at one and more than one child or children in rooms 111 and 112 of Robb Elementary School. And that as a peace officer for the Uvalde Consolidated Independent School District, the defendant had statutory duties to act as follows: to prevent an offense against a person about to be committed in his presence and use as much force as necessary to prevent the commission of the offense and no greater, or after being informed in any manner that a threat had been made by one person to do some injury to another person, to prevent the threatened injury if within his power, or to protect the safety and welfare of the people in the jurisdiction of his school district. And that the defendant did not voluntarily deliver to Jose Manuel Flores Jr. to a designated emergency infant care provider. Relevant statutes. A person commits the offense of endangering a child if he intentionally, knowingly, recklessly, or with criminal negligence by omission engages in conduct that places a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. A person commits an offense by omission only if the person has a duty to act. A peace officer has a duty, A, under the provisions of Article 6.06 of the Texas Code of Criminal Procedure, to prevent an offense against a person about to be committed in his presence and use as much force as necessary to prevent the commission of the offense and no greater. B, under the provisions of Article 6.05 of the Texas Code of Criminal Procedure, after being informed in any manner that a threat has been made by one person to do some injury to another person, to prevent the threatened injury if within his power. C, under Section 337.081 of the Texas Education Code, to protect the safety and welfare of people in his jurisdiction. Such endangerment is not an offense if the defendant voluntarily delivered the child to a designated emergency infant care provider under Section 262.302 of the Texas Family Code. Definitions: conduct, an act or omission and its accompanying mental state. Omission, a failure to act. A person commits an offense only if he voluntarily engages in conduct, including an act, an omission, or possession. A person who omits to perform an act does not commit an offense under the law, unless a law provides that the omission is an offense or otherwise provides that he has a duty to perform the act. Intentional conduct, a person acts intentionally as required by this offense if the person has the conscious objective or desire to engage in the conduct that would place a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. Knowing conduct, a person acts knowingly as required by this offense if the person was aware that his conduct was reasonably certain to place a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. Reckless conduct, a person acts recklessly as required by this offense if there is a substantial and unjustifiable risk that his conduct would place a person younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. This risk is of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the person's standpoint, and the person is aware of but consciously disregards that risk. Criminally negligent conduct. A person acts with criminal negligence as required by this offense if there is a substantial and unjustifiable risk that his conduct would place a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. This risk is of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the person's standpoint, and the person ought to be aware of that risk. Bodily injury means physical pain, illness, or any impairment of physical condition. Designated emergency infant care provider means an emergency medical services provider, a hospital, or a child placing agency licensed by the Department of Family and Protective Services that agrees to act as a designated emergency infant care provider and has on staff a person who is licensed as a registered nurse and who will examine and provide emergency medical services to a child taken into possession by the agency. Excuse me. Application of the law to the facts. You must determine whether the state has proven beyond a reasonable doubt 6 elements. The elements are that number 1, the defendant in Uvalde County, Texas, on or about May 24th, 2022, engaged in one or more of the following omissions. A, after hearing gunshots and after being advised of the general location of the shooter by witness 1 and having time to respond to the shooter, the defendant failed to engage, distract, or delay the shooter, or failed to attempt to engage, distract, or delay the shooter, or failed to otherwise act in a way to impede the shooter until after the shooter entered rooms 111 and 112 of Robb Elementary School and shot at a child or children in rooms 111 and 112, and or B, after hearing gunshots and after being advised of the general location of the shooter by witness 1 and having time to respond to the shooter, the defendant failed to follow his active shooter training to respond to the gunfire by advancing toward the gunfire until after the active shooter shot at one and more than one child or children in rooms 111 of Robb Elementary School. And number 3, Jose Manuel Flores Jr. was at the time a child younger than 15 years of age. And number 4, the defendant acted intentionally, knowingly, recklessly, or with criminal negligence. And number 5, the defendant was a peace officer for the Uvalde Consolidated Independent School District and had a duty to act by virtue of the provisions of the endangering of a child statute and or other state statutes, providing that he had a duty to perform the said acts that he omitted to perform. And number 6, The defendant's conduct was not a voluntary delivery of Jose Manuel Flores Jr. to a designated emergency infant care provider. You must all unanimously agree on the elements listed above. If you agree the state has failed to prove beyond a reasonable doubt one or more of the elements listed above, you must find the defendant not guilty of count one, endangering a child. If you agree the state has proven beyond a reasonable doubt each of the elements listed above, you must find the defendant guilty of count one. Stipulation of facts by the parties. The defendant has stipulated that the named child victims in the indictment either suffered death or physical bodily injury on May 24th, 2022 as a result of the mass shooting at Robb Elementary School in Uvalde, Texas. All right, counts 2 through 29, ladies and gentlemen, instructions on those counts endangering a child. The state accuses the defendant of having committed the same offense of endangering a child in counts 2 through 29. Specifically, the accusations in these counts are the same as those in count 1, except that the alleged victims, all children younger than 15 years of age, are as follows. Count 2, Azucio Sergio Garcia. Count 3, Xavier James Lopez. Count 4, JC Carmelo Ivanos. Count 5, Annabelle Guadalupe Rodriguez. Count 6, Alexandria Anaya Rubio. Count 7, Leila Marie Salazar. Count 8, Elena Torres. Count 9, Rogelio Fernandez Torres. Count 10, Nevia Alicia Bravo. Count 11, Jacqueline Jaden Casares. Count 12, McKenna Lee Elrod. Count 13, Elena A. Garcia. Count 14, Tess Marie Mata. Count 15, Miranda Gail Mathis. Count 16, Alethea Haven Ramirez. Count 17, Maita Elena Rodriguez. Count 18, Jayla Nicole Silguero. Count 19, Ameria Joe Garza. Count 20, Noah Oscar Arona. Count 21, Chloe Melinda Torres. Count 22, Jordan Demetrio Olivares. Count 23, Jadian Canizales. Count 24, Samuel N. Salinas. Count 25, Kendall Faith Olivares. Count 26, Mia Sorillo. Count 27, Gilberto E. Mata. Count 28, A.J. Martinez. Count 29, Maya Zamora.
June, I see it. I'm working on it. Thank you.
Relevant statutes and definitions in regard to the above. The relevant statutes and definitions for counts 2 through 29 are the same as those that have been set forth previously in the instructions for count 1. Application of the law to the facts, you must determine whether the state has proven beyond a reasonable doubt the same 6 elements listed in count 1 previously with respect to each of the remaining counts 2 through 29, except that the names of the victims alleged in these counts are different. Likewise, you must all unanimously agree on all such elements with respect to the remaining counts 2 through 29. With respect to each of the remaining counts 2 through 29, if you all agree the state has failed to prove beyond a reasonable doubt one or more of the 6 elements, you must find the defendant not guilty of that particular count. However, if you all agree that the state has proven beyond a reasonable doubt each of those 6 elements, you must find the defendant guilty of that particular count. Rules which control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go to the jury room. Your first task will be to pick your foreperson or your presiding juror. The foreperson should conduct the deliberations in an orderly manner. Each juror has 1 vote, including the foreperson. The foreperson must supervise the voting, vote with the other members on the verdict, and sign the verdict sheets. While deliberating and until excused by the trial court, all jurors must follow these rules. Number 1, you must not discuss this case with any court officer or the attorneys or anyone not on the jury. Number 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the case until all of you are present again. Number 3, you must communicate with the judge only in writing, signed by the foreperson and given to the judge through the officer assigned to you. Number 4, you must not conduct any independent investigations, research, or experiments. Number 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Your sole duty at this point is to determine whether the defendant has been proven guilty. You must restrict your deliberations to this matter alone. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your verdict sign his or her name to the particular form that conforms to your unanimous verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Date, January 20th, 2026. Sid Harrell, judge presiding. Ladies and gentlemen, there are 29 verdict forms attached. They are all identical other than the name. I'm going to read the first form to you to illustrate what they all say, and the rest will be attached to the verdict for your consideration. Now, the verdict forms are not to suggest to you what your verdict should be. However, should you decide to use these verdict forms, each and every one must be signed by the presiding juror, the foreperson, indicating your unanimous verdict. Count one, verdict, not guilty. We, the jury, find the defendant, Adrian Gonzales, not guilty of count one, endangering a child, as charged in the indictment, with a signature line for the foreperson and a line for the printed name of the foreperson. Verdict, guilty. We, the jury, find the defendant, Adrian Gonzales, guilty of count one, endangering a child, as charged in the indictment. Again, signature line for the foreperson and a line for the printed name of the foreperson. Identical verdict forms for each of the 29 counts alleged. All right, ladies and gentlemen, at this time, both sides have an opportunity to argue the case. The state does have the burden of proof, so they have the opportunity to open and close the arguments. I will ask them to address you at this time.
Abraham Lincoln said that it is much the duty of government to render prompt justice against itself as it is to render the same against the people. What he was saying was, we have a government comprised of prosecutors and police officers whose job it is.
Okay, guys, I'm looking a little glitchy over here. It looks smooth in the output. I'm going to take this off for a second. Don't panic. And I'm going to reboot it exactly where we are now. I'm just resetting. I'm just going to reset this for a moment. Okay. Just give me a second, because that's what happened. It paused and I was like trying to get it to play again and it wouldn't play. So let me do that. Okay. And here we go.
Is to render justice against citizens when they violate the law. And that's what we're accustomed to. Prosecutors and police officers working together when someone has violated the law so that they may be held accountable, so that we may have peace and dignity in our state. But Lincoln reminded that no one is above the law, that those in government can also violate the law. And when that happens, it is the government's job to also render justice against those they work with. And so on May 24, 2022, when 19 children were slaughtered, 10 others were injured, Texas Rangers from all over the state came to Uvalde, Texas, investigated the crime scene, talked to witnesses, analyzed the case for up to a year. And after analyzing the case, one of the members of the government has been brought to you for justice. But ultimately, in our country, in a democracy, it is the people that decide their government. You do that by electing officials. You do that by sending letters or requests to have the law changed. And when one of the members of your government violates the law, you decide whether or not that is acceptable. Because make no mistake, the 12 of you will set the bar for law enforcement in these situations. If it's appropriate to stand outside hearing 100 shots while children are being slaughtered, that is your decision to tell the state of Texas. And by the same token, if that is not appropriate, that is not how we expect officers that are charged with the duty of protecting children to act, that will also go out from this courtroom. The judge has told you that your oath was to render a true verdict according to the law and according to the facts. He has given you the law, and it is that same law that we discussed in Fort Dyer some 2 weeks ago. You recall we talked about this is a special statute because we're dealing with a special group of people. We're dealing with children under 15 years of age. And so we're expected to act differently when we're talking about children that are frail, can't defend themselves, 15 years old or younger. And in this law, the law of child endangerment, none of us are allowed to endanger a child. None of us can point a gun at a child, put them in danger, put them in harm's way. But there is also the protection that if you have a duty to act, you can't stand by while the child is in imminent danger. If you have a duty to protect the child, you can't stand by and allow it to happen. We talked about the people that have a duty. Parents have a statutory duty, and police officers have a statutory duty. And those two sets of people cannot fail to act when a child is in imminent danger. And so the charge in this case is that these 29 children were in danger. Not just danger, but imminent, immediate, close at hand danger. And that there was a man who had a duty to act, who failed to act. And that failure to act, he was aware or should have been aware that that placed those children in danger. But we're also very specific about it. How is it that he failed to act? He failed to act after being aware that shots are fired, being told the general location of the defendant, of the gunman, having time to respond. He failed to act by either engaging, distracting, delaying, or even attempting to do those things. And also being aware that shots were fired and being advised of the general location of the shooter and having time to act and having been trained in that active shooter training, he failed to follow his training to respond by advancing toward the shooter until after the children in 111 and 112 had been shot. That is the obligation the state has to prove to you beyond a reasonable doubt. Two other quick mentions of the law that the judge has given you that I'm afraid we may not have discussed in detail on voir dire. The first was that the defendant must engage in a voluntary act. The first was on causation. We talked about when you have child endangerment by omission, there can be two people that can be held responsible. The person that is causing the danger and the person that has a duty to prevent that danger failing to act.
Yeah, I'm just going to object to that. Sorry, at this point, there's concurrent causation is on his board, but not in the charge.
I'm not discussing that. They just now went through that, Judge, and I just didn't point it off. I didn't say concurrent cause. I talked about what we talked about in the law that.
Okay. All right, I'll overrule the objection. Go ahead. Ladies and gentlemen, I just noticed the clerk brought to my attention, we were working on that charge yesterday. Your date's wrong on that, it's 21. January 21, the last page of it. So it says 20, but it's 21. You know that. Go ahead.
The second issue is voluntary. The defendant must engage in a voluntary act. That's as opposed to an involuntary act. An involuntary act, I believe we talked about during jury selection, is, you know, if you stumble and knock somebody over an embankment and they're injured, that wasn't a voluntary act on your part. A gust of wind blows you into somebody. You're not responsible for that kind of conduct. If somebody swerves into oncoming traffic and hurts somebody, that certainly looks like you should be responsible for that conduct. But what if it was the very first time you'd experienced a heart attack and you lost control of the vehicle? That's not a voluntary act. That's an involuntary act. You're not responsible for that. But if you make a decision to seek cover and ask for cover as opposed to going in and stand by while people are being injured and killed, that is the kind of thing that's the voluntary act. It is defined in the statute. And finally, on mental states, there were 4. Intentional is not really something to discuss. Nobody believes that Adrian Gonzales meant for this to happen, wanted this to happen. But the other 3 deals with their level of awareness. Knowingly means simply you're aware that by standing by, it's reasonably certain the children will be in danger. Aware is reasonably certain. Reckless is 1 degree lower than that, and that is not that you're reasonably certain the conduct will happen, but reasonably certain that there is a risk, a substantial and unjustifiable risk that the children will be in danger. But there's still an awareness. But in addition to that, there's criminal negligence, in which the law is simply, you should have been aware, based on all those circumstances, that by you failing to act, the child was at risk. So that's the mental state. Not that he intended it, wanted it to happen, but at minimum, he should have been aware that by standing there, hearing 100 shots, he should have been aware the children were in danger by his failure to act. And so then we move into, and beyond the law, into what the state's case was. And it's pretty straightforward. This is not the order we put it in, but this is just the order I drew it up, because training is a big part of who Adrian Gonzales was. And you have the training that he trained others, because that tells you what he knows. And it also tells you a lot about what the state has done before you got here. In that lesson plan that was introduced into evidence, it tells you that amidst active shooting, the state of Texas stepped forward and required active shooter training for school police officers. And that active shooter training includes stop the killing, stop the dying. And it's not terribly complicated. The training is go to the gunman, advance toward the shots. Pretty straightforward. Not complicated, not hard. Go to where the gunfire is. That's what the training is. We brought you evidence that Adrian Gonzales taught the class that said, advance to the gunman, stop the killing, stop the dying. Even if you're the only one there, solo entry, you've got an obligation to go in. Why? Because in our state, we have a priority of life. Innocent civilians, their priority of safety is above the police officers. The officer going through this training is aware that the safety of the innocent is above the safety of the police officer. And in Adrian Gonzales's training, he says, the citizens have a right to expect that. And if you're not willing to do it as a first responder, find another career. Adrian Gonzales is teaching his fellow officers, take your job seriously. It's okay to move aside. It's okay if you're not up to that. Let somebody else step in that is up to it. Because as citizens, we have the right to expect that. When we call for help, we have the right to expect somebody that is put on the badge and put on the gun and put protect and serve on the side of their car will do that when we call. Because if they're not willing to do that, where are you? What are you left with when you're in danger? Who do you call? And so Adrian Gonzales, armed with this training, the next thing we spent a considerable amount of time on was the shot count. The casings along the west side, the casings along the hallway, the casings in 111, the casings in 112. And why did we spend all of the time on that? Because it's the state's position that each shot was noticed to Adrian Gonzales to advance toward the gunfire. Each shot was important to those 19 children and those 10 survivors. Each shot. But the shot count also, as we did that, and obviously if you have this kind of slaughter, there's going to be blood, and we apologize for that. But the blood also tells you a story of children engaged in this, doing as they were trained. To hide in the dark, remain quiet, and wait for the police. Did the defendant have time to act? We brought you videos, the funeral home videos, as well as the hallway videos, as well as dispatch, to tell you what he was aware of, when he was aware of it, and what was going on as he stood outside the fourth grade wing for 3.5 minutes before he made his first move, before he moved forward. We also brought you the defendant's statement. And the defendant's statement, I think, clears up almost the entire case. That is what he told the Texas Rangers shortly after this happened. If you're worried about whether or not he had notice and whether he had time to act and what his decision making was, Listen to these words from Adrian Gonzales. He's over there. He's over there. He's wearing black. I say, where? I hear shots going off. Hear sounds coming from behind the building. I get on the radio and say, shots fired at Rob's school, and give the location and where he is. Trying to get from the front of my vehicle to the back of my vehicle. There's only a tree and a building. She tells me he's over there. She's pointing, saying he's over there. He's dressed in black. I say, where? She says, the teacher's parking lot. I want to say I saw a black car at the end, and then I hear the rounds going off. When Melody Flores says he's over there, the teacher's parking lot, I hear the rounds going off. Some evidence of auditory exclusion. He tells the Rangers, as Melody Flores is telling him where he is, he hears the rounds going off. She goes, he's over there by the teacher's parking lot. Then I hear the sounds going off. I heard 7 or 9 shots while I was inside the building. The coach said parking lot in all black. That's when I heard the rounds start going off. I never saw him. I never went to the school until I got coverage over here. Then I made entry. I heard like 3 or 4 gunfire. When Pargus was the first one I saw, I told him to come to me for cover because he has a bigger unit. But he deterred and went to the other area. I knew there were kids in the class. That's why we didn't fire and hit the kids. I'm responding because they are saying the guy is running to the school. I didn't respond to the accident. That's a PD traffic. I'm going over there because they are saying the guy is going to the school and has a gun. Yeah, that's why I'm going to the school. And so the question is, if as Melody Flores is telling him where he is, he's in black, when does she tell him that? Do you really suppose that someone who risked her life to go tell the kids to get inside the door, that is that worried about those children, that turns to run, that when the police officer gets there, doesn't immediately say what she told you she said? He's over there, he's in the parking lot. Where? And she points. And then says, we've got to get in there. And isn't that consistent with what human beings do? Look at Gilbert Lamons. When he sees children in danger, just as Melody Flores sees kids in danger, what does he start saying? Get in there, get in there, get in there, get in there, get in there. Repeats it over and over and over again because of the urgency of the children being in danger. And Adrian Gonzales decides to go to the back of his car, call Mariano Pargas because he's got a bigger unit, and says, I'm not going in until I get covered. We proved to you the children were in danger. And I know that was a horrible thing to have to experience. But each one of those children deserves to be revived. And you needed to know that those 60 shots in rooms 111 and 112 before Adrian Gonzales entered, those shots ended those kids' lives. This was over. before he went in. A whole lot of blame for a whole lot of officers. This was over while he stood outside. And we anticipated that the defendant would say, I was confused, regardless of what he said in his statement. And so certainly gunfire can be a confusing thing. But we brought you teachers that experienced that gunfire. And the teachers told you that experiencing that gunfire, they still put their kids first and they follow their training. Kids first, follow the training. Melody Flores did it. Miss Deming in room 104 did it. Miss Ogburn in 102 did it. Miss Robin did it with her children. And Mercedes Salas said, not till I get my kids out. You can talk about confusion, but their priorities were where they needed to be. Children first. And then we talk about the defendant's evidence, or the defendant's case, let me say. We started very early on that Monday, but he didn't have time because it was too far. It was 45 seconds over there. So we brought you evidence that somebody that covered that almost that same distance was able to do it at a jog in about 11 seconds. It was further than that, given 15, 18 seconds, but it certainly wasn't 45 seconds. And then there was the representation. There were no shots fired toward Melody Flores. There's no evidence of that. And so we brought you the evidence of the 8 casings on the side of the parking lot, the shot into room 24. Well, those 8 shots were accidental discharge by a man bent on killing kids. He just made an accident, swung his gun around and fired those shots, not toward Melody Flores, but toward that window. And so we brought you the casings. One picture shows 3 of the casings, which you remember the FBI agent said we had to go back several times. And so there's 2 more markers that are additional. There's 5 casings. There's 5 shots in the glass and 5 shots directly across up into the, not 5, but shots shrapnel up into the ceiling and down. So where are those 8 casings being fired? If we have those 5 taken care of, as well as in room 104. Well, we have room 24. And so they tell you, well, that could have come out of room 111. So we brought you evidence that it was circular or almost oblong, saying that's the wrong angle. But more important than that, there's a piece of conduit running up the building. That bullet would have to pass through without leaving a mark. That evidence about Melody doesn't know what she's talking about is so you don't trust Melody Flores. And if you have any hesitancy on Melody Flores, go back to the defendant's statement where he says she told me where he was, what he was wearing, and then I heard the shots. We had a lot of information about slicing a pie and how long that must take. No way you have time. You got to get over to the side of the building and slice the pie. You can't do it quick. You have to do it slowly so you don't put yourself in harm's way. There's no evidence Adrian Gonzales got to a point where he could slice the pie. And we had evidence from their expert said, slice the pie. How about taking a quick peek? You have cover, you have concealment, the gunman can't see you. You just peek around from a safe position. Well, it wasn't really cover. Well, it's not cover from the south side, but the gunman's over there. Adrian can see that way. It's not cover from the west side. If the gunman's over there, he's not over there, which Adrian can see. But it is covered from the northwest side, where the gunman is firing 16 shots. While Melody Flores is telling me he's over there. Echo. Adrian did tell the Rangers that there was an echo. So from his spot where he's standing, he's got to find out where that shot's coming from. And he can see on the east side it's not coming there. He can see on the south side it's not coming there. He can see on all directions except behind the building where Melody Flores is telling me he is. That's where it's coming. Not only that, but when Coronado runs up and he hears those shots within 2 seconds, he's saying, shots fired, get in the building. And Adrian Gonzales knows which building to go to. And Paige knows which building to go to. And they go to the building where the shots are fired and have been firing for 3.5 minutes. Well, let's talk about the doors, the responsibility of the doors. The doors would have slowed him up. Yes, the doors would have slowed him up. He had an AR rifle that penetrates glass. The glass is right next to the doors. He could have weakened that glass within a matter of seconds. It would have slowed him up 2 or 3 seconds to go through that door. You look at rooms 111 and 112 and you see the shots there surrounded around the window. May have slowed him up another couple of seconds if the door is locked. But we're not talking about a couple of seconds. We're talking about 3.5 minutes. Number one. Number two, the charge of endangering a child means you have to be aware the child is in imminent danger when you fail to act. And that failing to act, failing to lock the doors, did not happen as the gunman was firing the guns. The children weren't in imminent danger, immediate, close at hand danger when those doors weren't locked. Their failure to act at that point was not at the point where the children were in imminent danger, nor is there evidence they have a statutory duty to act. And in this case, let me say, there are adults we can be very disappointed in. There can be police officers we're very disappointed in. I don't know how you feel about everybody, all those people. I'm not proud. This is the case of the state of Texas versus Adrian Gonzales and the facts against him. And is he going to be held accountable for his lack of action? And so we concentrated our case on the facts against Adrian Gonzales. It's radio dispatch's fault because they didn't give significant enough information. They just said, wreck, man with gun.
Okay, I hate to break this, but I'm having a problem. I really am struggling with the fact that the judge is allowing that whimpering person, and I'd be whimpering too. I'd be crying too. But I thought that was not going to be acceptable in this courtroom. So you got closing arguments and you got people crying, and I'm shocked the judge has not said, hold up, everybody. If you cannot keep your emotions under control, we need you to leave. That is not fair to the defendant in this situation. Why is there no objections here? Just saying. We kicked people out for showing emotions earlier. Why are they permitted to now?
Shots fired. They didn't say if he was shooting.
My humble
shots at the
opinion.
door or not. That's important information we should have known. But their expert got on the stand and said, wreck, man with a gun, what does that say? Not a lot. A man can be with a gun, but not be all that dangerous. But what about shots fired? His testimony was, then it gets real. What does that mean to a police officer? Shots fired. Then it gets real. Then on your way over there, you got time to know I'm facing somebody where their shots fired. It reduces the confusion by the preparation. Shots fired. This is real. I've been trained. Shots fired at a school. Not the information in school. Shots fired. Rob Elementary, man with a gun. I've been trained. I may have to go in solo. It was the police administration's fault because they didn't assign a person to each school. I suppose that statement is really, if they had assigned somebody, as long as it wasn't Adrian Gonzales, the outcome would have been different. The defendant's case. Then we move to the other police officers, Page, Hill, Sauceda, Coronado. And I'll ask you to look through your court's charge and find where it says evaluate the conduct.
Y'all may not be able to hear it, but it's coming through on my end and it's coming through on the captioning. So maybe, I don't know what it is in, but I'm hearing someone cry, whimpering.
Conduct of Page, Hill, Sauceda, or Coronado. You're here to decide one case. But we're glad to talk to you about these officers. Page, the funeral home tape alone shows you that he shows up 2.5 to 3 minutes after Adrian Gonzales is there. That along with the raw videotape shows you that he entered the building within 30 seconds. He shows up. There's shots going on. He assesses the situation in 30 seconds. He's acting. He's acting. Not failing to act. Hill, you recall that it's Hill's responsibility because he was called to Old Carrizo Road. He goes to Old Carrizo Road. He arrives there after the gunman is already inside the school. After the 16 shots from outside have already been fired on the other side of the school. The testimony was there was radio chat about setting up a perimeter. So he sets up a perimeter. Because here's what officers do. They get dispatched and they act. And when they get there, they assess a new set of information and they act. And after he sets up the perimeter, then he joins other people. And yes, the testimony was 25 minutes before he goes in. But Ruby Gonzales told you that once those hallways get full, it can become dangerous to overclutter that hallway. So you find other things to do. Well, if there's a perimeter, doesn't that count for Adrian too? If Adrian got the call to set up a perimeter and he goes there, so be it. But then you gather additional information. And that is 16 shots being fired outside, 24 shots being fired in the hallway, 60 shots being fired in classrooms, and a teacher saying, he's over there, you gotta get him. And you respond after you get the additional information. Salcedo shows up 30 seconds after the gunman has started shooting. The gunman shooting into the glass, into the classrooms. That's before Salcedo gets there. Halfway up, you know it's when Salcedo gets there because the bag is dropped. And then shots are fired. 6 shots are fired from behind a long row of cars. You're talking about him having an instant in which the gunman we know is hurrying the last part of that trip. We know the gunman is not firing into the building at that point. He's firing somewhere else. They think they're taking shots. If it's behind the vehicles, there's school classrooms with glass windows. If it's to the south and west, there's a man in dark blue or black. Permission to fire. Being careful. And then getting in his car and acting and following his sergeant to the end of the corner where Coronado says, I believe that's Salcedo. Also jogging to find the gunman. He's acting. And Coronado arrived to the sound of, he said he was receiving gunfire. The man at the funeral home is telling me, I think he says 2 or 3 of the building. He's the officer that came that is used to these being bailouts, and maybe it's a road rage, and that's what he's used to doing, whereas a school officer is used to protecting the school grounds. And so he's thinking this is a road rage, and my guy's shooting at us because he doesn't want us to get him. So he goes around to cut him off. But in going around to cut him off, he's acting. He's acting to stop the shooter. You may not like his decision. You may not be proud of his decision, but he's acting. This is a failure to act case. And you know that he's acting because he jogs, he's looking for the gunman. And when he hears shots fired, he acts within 2 seconds. Get in the building, shots fired, and he goes in. He acts. And then the defense brought you evidence of the challenges that Adrian was facing. We start with tunnel vision. That's the whole issue about whether or not Adrian Gonzales saw the gunman in the parking lot. We have no trouble with the concept that he had tunnel vision and focused on the lady in peach. This charge does not start with Adrian Gonzales arriving at Robb Elementary. The charge starts specifically with after hearing shots fired, after Melody Flores, witness number 1, which you can conclude now is Melody Flores, told him the general location of the shooter, and then having time to act. That's when the case starts. So he has tunnel vision. Okay. Auditory exclusion. Perhaps he didn't hear the shots. Then why would you tell the Rangers when Melody Flores told me where he was, I heard the shots? How does that happen? This was really complicated Complicated set of facts I have to decide on. Complication, the training is you hear shots, you go to the gunfire. He heard shots and Melody Forrest was pointing where to go to the gunfire. There's nothing complicated about that. He's wearing black. He's over in the teacher's parking lot. Go to the gunfire. Perimeter. Why doesn't Adrian get to set up a perimeter if Hill gets to? Why didn't Adrian tell the Rangers? I heard I was supposed to set up a perimeter. That's why I set up a perimeter. That isn't what he said. He said, I waited for cover before I was going in. And finally, this is an issue of stress. And this is my closing remark. I'm sure you're tired of listening to me. That was a dark day. For 29 families, it was extremely dark, and they still wait justice. And I can't live that darkness. But I can say this, there were some bright spots. In that stress, teachers put their kids first. In that stress, kids made ways to try to defend each other. In that stress, kids comforted teachers. In that stress, kids came first. Adrian Gonzales had a duty to put the kids first. And he called for cover.
Proceed, John.
Yes, sir, please.
The monster who hurt those kids is dead. That monster is dead. And we told you from the beginning. And it is one of the worst things that ever happened. And I told you, the first time I stood up here and talked to you, I told you that you were not going to be the same person when you come out of this. And nor should you be. Nor should any of us. Witnessing the horror, the tragedy, the loss, it's immeasurable. It's immeasurable. It's unthinkable. That loss is unthinkable. Their loss, it's unthinkable for any of us. You know, I told you guys that I have a 4-year-old, a 1-year-old. And, you know, we told you we're from San Antonio. And obviously, you know, I want to go back and see him on the weekends after the first week. I went back. The first thing I did was my 4-year-old came downstairs and I hugged him. Right? I hugged him. Started crying. And his hair, you know, trying to, so he doesn't see it. He said, "Are you sad, Daddy?" I said, "No, I'm happy. I'm holding you." Because I know what a privilege, doing this case, I know what a privilege it is to hold that child. I do. Right? I know, I can just imagine what it's like to not be able to do that. And I can imagine the pain, and I can imagine the anger. I can imagine wanting to put somebody in that chair because I can't put the monster that did that to my child in that chair. I can imagine that. And I can imagine putting pressure. And I can imagine them responding to the pressure. And I can imagine them putting him in that chair him and only him, in that chair, to try to pay for the pain, to try to somehow this could cover the immeasurable and the immense loss. And so after I saw him on Friday, we have to come back here that Sunday after the first week. And Gary, he comes and picks me up. That's kind of what we've been doing. And my son comes out and he says, "Are you going to go help that man?" And that's what we told him was the reason I'm not there. I said, "Yeah, I'm going to go help that man." Adrian Gonzales. Because he needs my help. He needs our help. Because they, the government, the power of the state, has decided that he has to pay for the failures of that day, for the mistakes that were made that day, and for all the pain that they feel. And it's not right. Because the person that they plucked out and put in that chair, that person showed, we showed throughout this trial, that person was acting. He was acting. He was trying. And what I hear from the prosecutor, what I hear from the state, and what you've heard this entire time, what you've heard is that they will massage all the facts, they'll twist them all into a pretzel. That every one of these officers is fine, he's not. They'll twist it. Well, look who acted. They acted. Well, Adrian acted. Well, he didn't act the right way. They acted. Well, they didn't act the right way. Well, yeah, but he didn't act the right way, and he didn't know exactly what was going on, and he remained. Well, yeah, but Adrian remained in the hallway. Adrian remained in the hallway after he got shot at. Well, yeah, he remained in danger at that point, but before that point, he remained, and he didn't know what was going on. Every fact that they tried to bring, they twisted it around. I'm going to show you. You're going to watch. I'm going to show you what they've done to twist this thing from the beginning to the end. But ultimately, what we're talking about is we're talking about duty, we're talking about burden, and all of those things. And I don't want one thing that I'm saying right now to make you believe that he doesn't believe that he has a duty to stop something that he knows is going on. Of course he does. He knows that. He was trying to do it. He started trying to do his duty. You look at some of these other people, no. They're not trying to do their duty. They're trying to stay back. And one of the things that the prosecutor said, he said, what you do here will tell law enforcement, give them how they respond. I'll tell you what, I agree with that, but not in the way that he's saying it. Because the way he wants you to believe it is what your verdict says is that next time these officers will make the right choice, the right decision. They will respond appropriately. They will be perfect. But the problem is that the issues here are not that Adrian failed to respond. They're not that he was intending not to engage. So you're not going to fix any of that, because I'll tell you, and I kind of hope it never happens again. I think we all know that it probably will. But those officers, what your verdict says is not going to make them perfect the next time. It's not going to make them not make mistakes. It's not going to make them not interpret things differently, strangely, weirdly, based on their own experiences. That's not what it's going to do. But I'll tell you what it would do. If you convict them, they're all going to be Randy Hill on that perimeter. There's nobody going in. What do? You went in. You convict them. What does it tell all the police officers? It's going to tell them, I'm not getting in that crap. I'm not getting in that chair. If I see somebody running towards the school, I'm not going after them, because if I'm mistaken and it takes me to the other side of the building from where the shooter is, and then I can't understand or know where the shooter is, I can go to prison. I can get prosecuted. So what you tell police officers is don't go in, don't react, don't respond, stay on the perimeter, because Randy Hill isn't sitting in that chair. He's not. Adrian Gonzales is here. Randy Hill is not. None of those officers are in that chair. That's what you're going to tell them. You're going to tell them, don't do it. And you can't tell them that. It's like, I agree with them. You can't tell them that. We cannot have law enforcement feel that way. Feel like if they're not perfect, they don't make a perfect decision. And that's where they go. Their family goes right there. There's nothing that's going to bring these kids back. There's nothing nothing ever is going to solve that pain. Nothing, not that. Because one of the things that Bill said to you is he said, those kids deserve to be remembered, and they do. But you do not honor their memory by doing an injustice in their name. You don't. That does not honor those children. By doing an injustice, by doing what they want you to do, by letting him massage the facts, by letting the pretzel go all the way around and miss everybody else, but keeps going right back to him, because that's what they need. We talk about the charge. If I can get it up. The duty. So remember this about what the court has read to you. And remember, I'm not saying he doesn't have a duty. Of course he does. But just like every officer, just like the officers in San Antonio, they all had the duty. But that's, and it may have sounded flippant when we compared it. We said, look, you're in San Antonio. You hear there's a school shooting, right? You didn't stop it. Well, no, because it's not happening in the presence. And the reason we're asking that question is because the law is specific about it. A person, they have a duty to prevent an offense against a person about to be committed in his presence. So the first thing you have to figure out is that in his presence? You know, and the judge told you, you know, use common meanings, but he is here, and he never, they're not even disputing, he never saw the shooter, ever. He is never in the presence of the shooter. Now, what Bill may say is, well, he didn't go to the presence. But that's not what this law says. Law doesn't say you have to go and find yourself and make yourself be in the presence. And I'm not trying to make any excuse about that. But the law is the law is the law. This isn't about you have to go seek it out and make it happen in your presence. The law is saying if it's happening right there, there's a duty. Of course there is. He was doing his duty. He was running to the danger. He was driving right in there. If that was the gunman, and God, I wish it was, he would have ran right over. That's what he was doing. He's going 50 miles an hour at that person. Now, what I'm glad is he didn't run the person over because he realized it's malfeasance. He realized it's a coach is what he thought, teacher's aide. But he realized who it was after it's already too late, but he's here. And from this point, that shooter is never in his presence, ever. There's never a time. The only time that he gets close is when he goes one of the first 5 people to go up that hallway. That is a hallway of death. Anyone going into that hallway knows, anyone knows, any police officer knows that those rifle rounds start coming that way as they're coming up the hallway. It's death. They don't have any equipment. They don't have anything to block it. It's death. He went in that hallway of death. See, and I thought about it because, you know, there's no way I can tell you about how they feel. But I thought about it as a parent. As a parent with kids there, if I knew that while my kid was in that classroom, somebody was going up that hallway, risking death to try to get to him, I'd appreciate it. I would. I mean, they're not perfect, but the person who did it, the monster, is dead. But he went up. A lot of people there didn't. A lot of people didn't enter that building until it was the room was surrounded on all sides by officers with rifles. Not one person on the side that he went in had one. Not one person had an AR. Not one person had a rifle. And they went in. Donald Page went in. Coronado went in. Chief Arredondo went in. People all went in and risked certain death. But the only time that he could have even been close to being in the presence of the shooter is when the shooter shot at him and Page through the wall. And you heard that testimony that there's gunshots going through the wall that they have to back up because not only can they not get to the door at all, they cannot get to the door. Joe Vasquez told you, that door, you're going to die at the door. You will die at the door. And I know that what the prosecution's saying is you should. Your job is to die at the door. But there was a lot of people out there. And if that's the training, die at the door, then everybody out there didn't follow. Everybody out there waited until there was shield. Everybody out there, Joe Vasquez included. Everybody. And you remember what Joe said? He said, you know, thought his daughter could be in there, and he still waits 50 minutes for shields, for a plan, for BORTAC. So that's what I'm saying. They're twisting it around, and they're saying, well, his job, every shot was noticed that Adrian had to go in and be the person to die at the door, to be the person that tried to breach solo breach, solo entry with nothing. But nobody else did that. So is that the training? Right? Like that's one of the things that you have the right to go, because that's count 2, disregarding his training. Is that the training? Because if that is the training, and all these officers have been trained, and not one of them does it, but only one of them sits there, right? Like you have to twist it every time. For every fact has to be twisted around. That no other officer, I mean, I'm assuming, I mean, they made a point. Everybody's trained an active shooter. But that's why we pointed out that, well, now it's become a barricaded subject, and that training's different than active shooter. Now, some people are treating it like a hostage situation, and that's different than active shooter. And so the point is with this training was never meant to be twisted and used like this. You think that anybody that's put on police training is going, yeah, and if you don't follow this, you're going to prison? I mean, that's not what they're doing. They're trying to give the best possible tactics and strategies to get to the best possible outcome. That's the point. But go back to the duty. If you find right there, honestly, he was never in the shooter's presence. Never was in his presence. Because that law, do not let them argue that law means that he has to go put himself in the presence. That law says it has to be in his presence. That's what that says. And if that's there, and you say that wasn't in his presence, then it doesn't apply. Under 605, he has a duty to prevent the threat, to do injury if within his power. So they have to prove to you beyond a reasonable doubt that it's within his power. Because what they're not talking about is, no, this is saying you have the duty to go and follow the gunfire. That's not what this says. It doesn't say you have a duty to follow the gunfire. What it says is if it's within his power. So all of the officers before the breach, all the officers that and I don't have anything bad to say about Joe Vasquez. That man went in there and he was willing to put his life on the line. But going in there like that in that room, it's not a whole lot different than going up that hallway, the first people to go up there without any protection, without any rifle rated anything, without any fire, without any rifles, without anything. But what that's telling you is that the reason that they waited is because it was within none of their power to get in that room. It was within none of their power to do that. It was not within his power to get in there and stop it. And it was not within any of those other guys until they got the right equipment. And then they went in and it was within their power. But if they haven't proven you beyond a reasonable doubt that Adrian could have done something to prevent, if beyond a reasonable doubt, then that doesn't apply. Then of course the education code just says he protects the safety and welfare of people in his jurisdiction. Well, of course. But that's not a duty that I don't even understand why it's there. It's not a duty to say, well, yes, and if you violate it, you go to prison. If you violate it, you're a convicted felon. If you violate it, you're going to be on trial. That's just telling police officers, and especially those who work at schools, that your duty is to do that. Of course it is. That's your job. Of course it is. But what we're talking about is we're talking about a man who is trying to do that. He is not trying to do that. He's not going, I'm not protecting anybody. Oh, shooter. And then drive off the other way. He doesn't drive around the building. He doesn't drive away from the gunfire. He's still trying to figure this out because we're talking about 1 minute and 48 seconds under their indictment. They keep saying 3 minutes, but it's 1 minute and 48 seconds. I showed you this in board hour. When we talk about beyond a reasonable doubt, possibly, probably, guilt likely, strong belief. If you have a strong belief duty, it's not guilty. Right there. That's why I'm talking about duty first, because as the prosecutor explained, if there's not a duty, then there's not. And not one of this is to be interpreted as me saying that he doesn't have a duty. We all have a duty to each other. He's a police officer, and he's going to do what he can. But when we're talking about criminal charges, if you even have to get to, well, it's likely that he does have that duty. It's likely that it was within his power. It's likely that it was within his presence. I have a strong belief it was in his presence. I have a strong belief that it was within his power. That's not guilty. It's a verdict of not guilty right there. That's the first consideration. But going to the indictment, after hearing gunshots and after being advised of the general location of the shooter, and Nico's going to talk to you a lot more about this, like It's convenient the way they're twisting it. It's convenient the way they're saying, well, of course, he was advised. She told him 1, 2, 3, and told him exactly where it was. And she pointed over, she's over here, pointed over there, and he knew. That's how they're presenting it to you. But that's not how we know that that's not how it happened. We know, we have to know, because she is frantic. She is very unclear about a lot of things. And so if you have a reasonable doubt that he was advised of the general location of the shooter, that's not guilty. If you have a reasonable doubt that he had time to respond to the shooter. Clicker slow on the uptake. Right, having time to respond to the shooter. If you have a reasonable doubt as to that, it's not guilty. Right, because what we established, and even now when he's reading Adrian's statement, shots fired, or she told me where it was, shots fired, I radioed it out. He's compressing time in his interview. We're going to talk about that. He's compressing that time. The way he's telling it, she tells him, and then he communicates it on the radio. We know that that's not what happened. We know that from the time of shots fired to the time he communicates it on the radio is a longer period of time, which is accounted for by the fact that he is trying to get the information out of her. Once he does, he communicates it. Once he communicates it, we told you, it's a second after this monster's already gotten in. That unlocked door, but it's already gotten in that door. When he communicates this out, the guy's already there. So having time to respond. Once he finally figures out what it is, does he have time to respond? And if he does respond, we were showing you, if he does respond over here, he's responding to something that's not even there anymore. He's doing basically what Coronado does, which is go completely away from where they saw him go in and go all the way around the building. So if there's a reasonable doubt as to having time to respond, that's not guilty. Any reasonable doubt as to any of these things, these are all elements that they have to prove to you beyond a reasonable doubt. And if there's any reasonable doubt as to any of these things, if there's a reasonable doubt as to Melody Flores and what she said, that doesn't say anything about her. That woman was traumatized. Of course she's going to be confused. Of course she's going to say it's a handgun when it's a rifle. Of course she's going to describe a completely different police car. Of course she's going to do those things because she's traumatized. But the reason we point those things out is they want him to be perfect, but they have to be perfect. They have to convince you perfectly, almost, beyond a reasonable doubt of their evidence. And that evidence rests on what did Melody Flores say and when did she say it? And they did not prove that. They did not prove it because even when she testified, Nico's going to go over it, she agreed that she was not just saying clearly, hi, this is what's happening, and this is where it is. She was saying a lot of different things. And it goes back to that chart. Anywhere you are, if you're suspected, if he's possibly guilty, if he's probably guilty, I told you, Bordire, most people get convicted at that probably. Because jurors go, well, he's probably guilty, so they convict him. But that's not what the standard is. That's not what the law says. The law says it has to be beyond a reasonable doubt. It's the only way that our Constitution works. It's the only way our system of justice works. Now let's talk about this. Let's talk about Ranger Hill. Look at this. I froze it on this animation that we did. Right at the point that Adrian's passing that spot. And that's where he has the shooter. He says it's approximate. Well, guess what? Approximate's not beyond a reasonable doubt. Their whole case is based on approximate guesses, speculation. We don't know. We're just really mad and we're upset that we have to put somebody here. Somebody's got to go in that chair because the guy who actually did this thing, the monster who did this, cannot go in that chair. He's dead. And good riddance. Good riddance.
I've been really trying to be quiet on this, y'all, because I want y'all to hear this, but I have to say, I think what he just said, if anything so far is going to resonate with those jurors, that might be it. They have to put somebody in this chair because the person that belongs in this chair is now dead. Now who are they going to put in the chair? I'm not arguing. I'm not going to tell you whether I believe he's guilty or innocent. I'm playing both sides of the coin. I didn't get to play a side of the coin because they didn't put much on. But I will say this, brilliant move.
Devastation and the destruction he causes, unlike almost anything that has happened to us as a country, as a people, and definitely the state of Texas. The devastation that he caused, children that young and that many, good riddance. But that's not him. But they have to have somebody. So what do? They give you an animation that looks like that. Which, as we know, we had to bring a witness. We had to bring Claudia to tell you and to show you. Look, you'll see him. He's walking right there. And you see him walking in between those cars, and he stays there. Now, in a few seconds, you're going to see Adrian's car drive by. His head kind of popped down when it happens. He's going right there. You see the white car is flashing right through. That's Adrian driving by him between the cars. So what would an honest rendition of what you just saw, what Claudia testified, what does an honest rendition of that look like? It looks like that. That's what that animation should have looked like. Because we have actual proof. And Ranger Hill can't act like he didn't know that existed. He told you about the puff of smoke. That's the same video he's looking at. He knows that this guy's between the cars. But he told y'all, they sponsored it, that he was here. Why are they doing that? Because they're willing to twist things. They're willing to twist things for you guys in order for you to do their bidding. But those kids aren't honored by an injustice in their name. They're not. It's not honored by a conviction in their name.
And first the window going out and then 111. Melody Flores is still urging Adrian Gonzales to go in. She sees the shot come through the window. Adrian Gonzales tells the police that she's the shot come through the window. Adrian Gonzales gets on the radio and says, guys, I think he's made it in the building.
See, that's what they told you at the beginning. They told you that Adrian Gonzales got on the radio and said, guys, I think he's made it in the building. Why are they telling you that? Because they want you to believe that he had that knowledge early, that he knew that he was in the building. What else did he say? In the opening statement to you, that Melody Flores saw the gunshot go through the window. When she testified, she said, I didn't see that. Why is it important? It's because Coronado radio, we've talked about it. And I feel like it keeps going into a memory hole every time it goes back over here. Right here, Coronado says, guys, I think he made it in the building. He established that. He said, he's the guy on the radio. He's the guy that thinks. Even Ranger Hill said, Coronado is the one who said that. Why did he say that? Because these three saw him do it. Because these three had line of sight. And he's radioing that around. And one thing we were clear to point out is that a gunshot did go off at the exact same time as that transmission. Why is that important? Because we don't know who heard that or who didn't. We don't know who heard Coronado go out and say that he's in the building. But we know that Coronado knew that or said that. And so that's the knowledge he has when he's driving around. Why is that important? Because prosecution, what are they trying to make you think? Coronado knew immediately that the gunshot fire was coming from the building. Coronado knew immediately that. Look at Coronado. He knew it immediately. Of course he did. He saw him move the building on the side. He knew it from here. Once he came around here.
Jack, see that's not admitted into evidence. There's no evidence that Coronado saw the shooter. There's no testimony about it or anything like that. So now he's misstating.
Objection, Your Honor.
Okay, once again, ladies and gentlemen, what the lawyers say is not evidence. If the evidence, based upon your recollection, differs, rely on your own. You may proceed.
Well, and I can understand why they're trying to fight against that. Because look, this is what I'm saying is we know that he radioed. I think he's in the building. When he's on this side of the building going to the other side, we know why. He testified. I thought he was going through the building, which implies that he knows that he went in to the building. But they keep fighting against that because knowing that he's gone into the building on this side, all their training, what does it say? Go to the gunfire. Even Ranger Hill they're twisting everything. They're twisting it all around. Ranger Hill said, well, yes, going to the gunfire is going all the way around here to the other side of the building, from where you saw him enter and from where you heard and saw him shooting into the building. So that to them is going to the gunfire. That to them is following their training, exactly how they're supposed to. That to them is working to distract, delay, all the things they've charged him with. Well, they're not charged because they did that, even though they watched this happen. Had to have. And then Mike Witzkel. Now, I thought this was interesting. Mike Witzkel, I mean, he's an interesting guy. He said, I'm here as an expert witness in training, right? He didn't have any opinion. This is the interesting thing. The state had every opportunity to have Mike Witzkel go, I trained this guy. And I've seen all this stuff that you've given. And I reviewed all of these things. And Adrian Gonzales did not follow the training that I had. They had every opportunity to do that, and they didn't. They didn't ask him. He said, I didn't review anything. I don't have any opinion about whether or not Adrian Gonzales followed his training. In fact, you don't have any opinion at all. You don't have any real statement from anybody about whether or not he followed his training. And the things that you have from the officers are always with a caveat. Yes, you run to the gunfire if you know where it's coming from. If you don't know where it's coming from, you take cover and assess until you know where it is coming from. That's the first thing. You run towards the gunfire if you know where it's coming from. You look at their active shooter trainings. All the active shooter trainings involve them seeing the shooter and then going after the shooter, which makes sense. But they are prosecuting a person that they will have to admit, and they have admitted, and they've stipulated and never contested that Adrian never solved the shooter. I mean, he talked about the death by PowerPoint. In Adrian's 40-hour class that they were talking about, the 40-hour class he took, he said, look, we do 75-25, the practical versus the death by PowerPoint. I'll point out that, and you'll see that in the training the prosecution mentioned about, well, Adrian taught a training. He facilitated a training. He did. There was somebody else who wrote the materials. There was somebody else who did it. And that's really what they kind of do. They have to facilitate for each other so that they can get their training hours. But in these trainings that are happening, in the trainings that are going on, all of the trainings are training them to come in, have a rifle, come in, go in and be prepared to come in and do those things, and mainly to come in and see the shooter. Mainly to come in and know where the shots and the shooter is happening. And what they have done is they have just said, oh, we don't care. Yeah, he said he didn't know where the shooter was. We don't believe him. We believe everybody else. Everybody else gets a pass. Everybody else. Randy Hill gets a pass. Saucedo gets a pass. Well, yeah. Saucedo said, I think I see him, permission to shoot. Well, we don't believe he said that. Or if he did say that, he had kids behind him, so he shouldn't shoot. That's crazy. That's crazy. Talking about this backdrop, that's crazy. And if that's the case, these officers are being overtrained on backdrop, because you do not fail to shoot a mass murderer of children because there's a backdrop where you could potentially shoot a child. You don't do that. You have to take that shot. And so if that's what they're saying, well, no, Saucedo has a reason why, because there's this backdrop. But then we pointed out, well, if Adrian did what they were asking him to do and came around here, we know now that by the time he transmitted, the guy's in the school, so he would have come around and nobody would be there. Thank you. But even if he came around and somebody was there, shooting back here that's his backdrop too. But no, not for him. No excuse we make for every other person there applies to him. And I think that there's something fundamental in each one of us. I think it's fundamental in each one of you that that's not fair. I think it's fundamental that that's not how justice is supposed to be done. It's not. It is not fair. It's not how justice is done, that they can do that and interpret every fact against him, but for everybody else, similarly situated or better situated. He agrees it takes 10,000 hours of practice to reach expertise. I mean, these are not experts. Adrian is not a SWAT expert. He is not an active shooter expert, right? He is doing the best he can, and this was obviously the worst situation of his or any of their law enforcement lives. 5 minutes to dress like one, 5 years to be one. I mean, the training is so extensive, and it's much, much more than Mike Witzkel gave 40 hours on that day. And then they talk about, well, you stop the killing, stop the dying. They never tell you how when he's training. They never say how. They never say, how do you do it? How do you do it if it's just you and a gun and they have a rifle and you're in an open field? They don't say how. They just say, do it. Go in, win the game. Now, this is what in his instructor course, CME does not endorse nor encourage going it alone. See, what I'm saying is that these are sending mixed messages to the people who are being trained. They're reading this, they're seeing it. And then when you're talking about beyond a reasonable doubt on count 2, did he follow his training? It's like, even in the training, they're telling you, well, you should go in, but we don't endorse, we don't encourage it. Because having greater numbers significantly improves a first responder's odds for success. Now, what does that mean, odds for success? Because what they keep saying is that there's a continuum of life scale, and there's a priority of life scale, right? And then
Video 82, it starts, there doesn't seem to be anything that needs to be under seal because it starts
being able to protect civilians.
in the bathroom and they walk out.
Because if you try to just run in and you don't have any of that, that shooter, remember the shield comes in when they finally came in, pop, 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 he's putting it right on the shield. The guy in the back of the stick, he comes in, shot in the head. That guy was ready. And anybody who approached that door was dead at the door. They were dead at that door. So what they're saying is the numbers improve the first responders' odds for success in saving lives because a dead police officer is protecting no one. And that's what his training says. That's the person they brought you to say what his training was. That's what the training says. So they're sending mixed messages to these officers. And then if you better read the mixed message the right way, or the way they want you to read it, otherwise you're in this chair. It's not right. We saw the training pictures. This is how they're training to respond to active shooter. You got 2 people, you got rifles, they're coming in together, they're coming in different ways. That's how they're training. But that's not how it was. And we said in those hundreds of pictures, they didn't bring me one picture where they're coming in with all they got is a gun. All they got is a handgun. Not one in the hundreds that they took at that training. Because they're training these officers to have the right equipment. Adrian didn't because the school district didn't buy it. Bailouts, we talked about it. Why is it important? Because everybody is responding strangely to this thing because of this red. They all think, they're going, well, it's okay that Coronado and them thought, well, this guy's running through the school because it's a bailout. He's just trying to get away from us. But it's not okay that Adrian thought that that could happen. It's not okay if Adrian's standing here going, well, these guys are here and I'm here and I don't know where these shots are coming from, but he's probably trying to go here. I still have a whole school down here. It's not okay if Adrian thought bailout, no, he didn't follow his training. What Adrian said, he cooperated every time. Remember, this is a day later, and you know he's experiencing time compression. You know he's doing that because he's saying, I hear the shots. She's telling me I radio it out. That's not how it happened. So he's going through the same problems that we've talked about in all the other witnesses having to recount and recall what happened. He's having that same issue. He drove to the danger. And Nico will talk more about it. And then hindsight bias. And here's the thing that they keep trying to get him on. They go, because hindsight bias for Adrian is when he's telling the story about what happened, he says, yes, it was a female. It was a coach. Because he now knows that that's the truth. At the time, though, he did not know that. At the time, he didn't think it was a woman. He thought it was the shooter at the time. But when he's telling the story, he's now telling it in a way, using the knowledge that he has, and he's explaining the story. And the same thing goes for when he's talking about what Melody Flores told him. When he's talking about what he understood, he did eventually understand what she was communicating and communicated it out. But in hindsight bias, he's not going through with the ranger, and the ranger's not asking, was she clear about it? Did you know beyond a reasonable doubt when you got out of the car that she said that he's over there and you knew exactly where it was? He didn't follow up with any of that. So what Adrian's doing at the time of interview is he's skipping all that stuff. And he's getting to, I figured out what she was trying to say, and I communicated it out on the radio. He skipped it all because nobody's asking him. Because when they interviewed him, they're not prosecuting him. They don't think he did anything wrong. Nobody does. Nobody does. So years later, after all of this, they had somebody's got to go in that chair. So ultimately, it's the same thing I said from the beginning. You know, I told my kid, and so I'm here, I'm helping this man. But I can't be the only one, and Nico can't be the only one, and Gary can't be the only one. He needs your help too. Y'all are all citizens, and he needs you. He needs you to look at these facts as you have. Y'all have been very attentive, and y'all have to see very horrible things and hear horrible things. A lot of those things didn't have anything to do with those 3 minutes. Why did they bring it? You know why they brought it. You know why they tried to do it. The horror to make you so angry with him that you convict him. It played on your emotions. They presented all that in front of them. They're trying to do all of that, but they're not really going to what Adrian was experiencing and thinking and feeling on that day. But the one thing you do know, he went up that hallway. The one thing you do know, he went after somebody he thought was the gunman. That man didn't just stand by. He acted, except they just ignore all of his actions because they're trying to pretzel it, massage it, get it in there, do anything that they can to get the conviction. It's the most horrible thing, one of the most horrible things ever. One of the most horrible things that's ever happened in this state. But those kids are not served. The memory of those children that I agree should be honored is not honored by an injustice in their name. It's not. And so we're asking you to find him not guilty.
All right, ladies and gentlemen of the jury, we had discussed prior to beginning the argument to take a break at some point, and everybody agreed this would be a good time to do it. So take 10 minutes and we will resume the arguments, but do it as quickly as you can. We'll be in recess for 10 minutes. Remember my instructions, do not discuss the case.
Okay, so what do you guys think about this? Now, right now, the other case has a cop car going and the siren in my ear, and I'm about ready to go, "Bleh." Tag correctly. Hi, baby shark, do, baby. I've seen you here, boo. I just didn't want to interrupt. Hello, everybody. Thank you so much for joining us today. I'm going to show you what's in my ear, y'all.
God, you people.
Hold on. That's in my ear right now.
Bravo, the patient is unconscious. Apparently she was stabbed in the neck. She's upstairs in the bedroom.
Sorry.
Oh no!
That was shot is in the bedroom downstairs.
Oh, y'all. I'm going to zoom. Hold on.
Let me ask.
Hold on. I'm zooming. My mouse will cooperate. All right, we're going back over here. Oh, wrong one. I gotta get it. Oh, so that is going off of my ear at the same time that I'm talking to you guys, and it is so difficult to talk with that going off in my ear. It's like, oh, yo, it's still going off. Like, yo. Nichols is tapping in, y'all. Yes, he's going to tap it in. How do you still hear it? I have the new trial on.
Guys, you gotta go a little faster, huh?
All right, it's not sharing well. Give me a minute. It's glitching. Okay, now is that better?
Members of the jury, when we recess, the defense was in its closing argument. You may proceed.
Closing counsel.
I think what we're all struggling with.
Are we good?
One person
Nico is back. Can you hear him?
do such a horrific and evil act to those children, and it's real. I mean,
It's
we're all
still
thinking
going.
it. We're not immune from it. Everyone's thinking that, and the issue is that generates emotion. This has been an emotional trial. I can only imagine what it is to the families, and I'm going to talk about that in a second. I know it's been emotional for you. We've been watching you, rightfully so. It's been emotional to you. It's been emotional to us as well. Do you not think that that burly man, when he goes home and he gave you that story about his son, that he's not digging his face in his chest, weeping? I have permission to say this because he did. Weeping. Do you not think that Gary, when he's doing FaceTime with his twins, that he stays on a little bit longer or lets them call past their bedtime so he can talk to them, never knowing if that's that last time? Do you not think that Michelle doesn't rush home to go to her granddaughter's games? Because she does. It's emotional for all of us. Or Joseph, and he gets away and disappears at the house that we're staying in because he wants to talk to his children, making sure they're okay. I shared with you in jury selection the journey my parents went on and my family went on with the murder of my brother in our driveway. Do you not think that when I close my eyes that I don't rethink picking up my mom off the ground in our driveway, loading my brother's body on the gurney after they finished the investigation and helping my pop wash off my brother's blood in our driveway? There's nothing like a mama's cry. Nothing like a mom's cry. You can't explain it. Nothing compares to it. And that's real. We don't ignore that. It's never been us against the family. It's never been Adrian against the family. It's been a pursuit for truth. Remember the totality of the circumstances? It's a pursuit for truth. And because this has been so emotional, the only way that can be dealt with in a justice system is through a jury trial. I love a jury trial. I love the justice system. Thomas Jefferson, as we talked about in jury selection, we talked about Thomas Jefferson. This has a little bit of a delay. I consider trial by jury as the only anchor ever yet imagined by man, by which the government can be held to the principles of its constitution. One of our founding fathers believed that. I do. In a system of the people, by the people, and for the people, you're the equalizer. You're the one that has the final say. With all due respect to the judge, who I respect very much, not him, not the bailiffs, not the government for sure, not even the defense, it's you, it's the people. That's why I love a jury trial. And it deals with the emotion. It's the only way to balance this emotion and reason. And I say this respectfully as I can. They're trying to hijack your emotion to circumvent your reason. That's what they're trying to do. But they're your emotions, but they're being hijacked. We know that. So how do you deal with that? Because in a world where we don't agree on anything, we definitely don't agree on politics. We don't agree on worldview and religion. We don't agree on definitions. Most people agree, no matter where you're at, most people agree that we don't want innocent people convicted and punished. Most people agree on that. And the only way we do that is through the justice system. And the representative of that is Lady Justice. She represents the justice system, not Lady Liberty, it's Lady Justice. And this comes back from the Greek times, the Roman times, where there was a polytheistic society and there was Greek gods, and she was the god. I don't believe in Greek gods or goddesses, but she was the goddess of order. The justice system is supposed to bring order to a society. And everything means something on this symbol, right? The blindfold means something. She doesn't look at politics. She doesn't look on whether you're a Hindu or Buddhist or Islamic or atheist or agnostic or that I'm a Christian. She doesn't look at any of that stuff. What she does is she tries to get the facts and the law and merge them together to reach this elusive concept called justice. The sword. The sword represents strength. The justice system has to be strong. There's something called the death penalty and life imprisonment. That's in the justice system. So the justice system should have a sword aspect to it. And then her foot's on a book, because you have to have a command of the law, right? You have to know the law and have a commandment to dispense it properly. And her foot is on the book as she controls the law. And regardless of your religion or your worldview, the universal symbol of a serpent is evil. And the justice system should smash out evil in a society, true evil in a society. But yet she has those scales. And these scales are important. These scales say, I don't care about those cameras. These scales say, I don't care about the false narrative that's been out there. These scales say, I don't care about all the resources of the government. The scales even say, it doesn't even matter what the judge thinks. The scales says is we have to balance all that out, look at everything, and come find this concept called justice. And I love it. I love her. I loved her when I was a DA myself in Bexar County, as we talked about, when I made death penalty decisions, when Jason and I were prosecuting murders. I loved it. I love it as a defense attorney, sitting at that table, either defending people innocent like Adrian of an allegation by the government with all the resources. I love it. And in a world that has this dichotomy and this battle, the justice system brings us all together with a blindfold, not made of mesh, and not lifted up when it's convenient. Stays on the whole time. And so this is the point, though. This is the point in a trial, in a jury trial, and this is the point in our justice system, where Lady Justice takes the scales and she hands them to you. And now you have them. And that's what we're arguing to you. And that's what we've presented to you. And so all of this gets me to a point of where I'm in a dilemma. Let me tell you what my dilemma is. My dilemma is that I'm a passionate person, if you haven't noticed. And my passion, I think, can be a strength, but can also be a weakness. And so I wonder to myself, if I look like I haven't slept, it's because I haven't. Did I do too much? Was I too passionate? Was I too aggressive? Or did I not do enough? Did I not ask the right questions? Should I have gone even harder? And I struggle with that. But my dilemma is I can't apologize for it. And I won't be fake. And I won't tell you something that I don't believe. I haven't done that since jury selection. I won't start now. And so I can't apologize for it. And because I can't apologize for it, all I can do is ask you for grace. Just extend some grace to me. So if I've done anything, if Jason's done anything, if Gary's done anything to offend you, please, you don't have to now, please hold it against me or Jason or Gary, not against Adrian, okay? So that's what I'm asking you to do for us. And so we have to look at things, because what came up during the trial and at the beginning when I told you is there was a concept called totality of the circumstances, right? This case, ultimately, we're going to consider everything, allegedly. We want you to consider everything, but this case boils down truly to 1 minute and 48 seconds. Not 3.5 minutes, not 77 minutes, to 1 minute and 48 seconds. And it came up during the trial. And so Jason talked to, how do we know that? I'm not making that up. I'm going to their charging document. I'm going to their instrument that they charged Adrian. It goes up until after the shooter entered the room, 111 and 112. Until after the active shooter shot at one child or children in rooms 111. So it's from when Adrian showed up at the scene as the shooter is there, and until that shooter goes into those rooms and does what he did to those children. So we have times on that. That's what I'm saying. We have times. We know. Remember this? It's over here, but we took a picture of it. So Adrian parks. It's not contested. Adrian parks at 11:31:55. He parks. We'll talk about what he was responding to and how other people responded and how Adrian responded as he's going to what he thought was the danger. And we'll talk about shots fired. That's true. He calls shots fired because he hears them himself, but he parks at 11:31:55. He's not at 11:31:55 knows what's going on. At 11:31:55, he doesn't have a full concept of what's happening. He just parks at 11:31:55. And the shooter enters the building at 11:32:58. That's 1 minute and 3 seconds. And then some time goes by, 22 seconds later, he's shooting at those doors, and then 20 seconds later, he's in. If you add it all up, it's 1 minute and 48 seconds. That's what their indictment says. It's not 3.5 minutes. It's 1 minute and 48 seconds. Parked, enter the building. That's it. And then there's 22 seconds later, and then he enters again. 11:33:43. This is when he enters room 111. This is where we get the extra 45 seconds. And that's why I say 1 minute and 48 seconds. I'm going by facts that you've heard. They're charging in. No one's making things up on our side. Okay? I don't know what happened there. Give me 1 second. It held down on purpose. I'm trying. Give me 1 second, guys. Okay. Okay, so here's what the government wants you to compare Adrian's actions to others. So let's do that. And that's all we were doing during the trial. We were asking questions. We got permission. I mean, Mr. Espinosa sat to your right, and then Mr. Starbeck over your right shoulder, sir. And we asked everybody permission. For where you were sitting, Mr. Pena was between you two. And we remember in jury selection, we talked about that. And we got permission from you to be able to ask tough questions, even about sensitive matters. We did. And everyone said yes. So let's compare some actions. We're going to compare the actions of Mendoza, Saucedo, Coronado, and eventually Hill. And yes, they could figure that out during trial, so of course we're going to talk about it. So just to lay the ground, you guys know this already. So here's an aerial view. We can't even see Adrian's car. It's so much to the southeast side. But Coronado, Mendoza, Saucedo are on this side, a little bit outside. You've seen this picture multiple times. This is the scene. Here's a better view. We can see Adrian's car way over here. He's driving into the eye of the storm. Many witnesses said that. He drives all the way to the back. And then we have those 3 officers still at the corner. Here's the west door, and here's where the shooter was shooting. We have evidence of that, and he enters this door at 11:32:48. So let's compare Adrian and Officer Mendoza. Adrian drove into danger. Officer Mendoza stayed away at the perimeter. Adrian had no line of sight, not contested. Christina's not going to come up here and tell you that he had line of sight. Mendoza was the same side. He was on the same side as the shooter. Adrian was alone. Mendoza had backup. Adrian was one of the first 5 in the building. Remember, we're going to talk about that first 5 because Joe Vasquez and others talked about that first 5 and what they did and what they potentially prevented. Mendoza enters the east door at 11. The east door, even though he's on the west side, the east door at 11:42:48. But before that, he drives away, not towards the gunfire. When he's facing the door, when he's looking, when he has backup, and someone has an AR-15, we're going to talk about Saucedo next. He drives away, not towards the gunfire. Remember that pretzel that Jason's talking about? There's one of them. Let's do some more comparisons because they're going to compare Adrian to everybody else. Adrian and Officer Saucedo. Adrian drove into danger. Officer Saucedo stayed away at the perimeter. Adrian, no line of sight. Saucedo saw the shooter, and we're going to look at the video in a second, and asked to shoot. Adrian, alone. Saucedo, God bless you, has backup. Adrian has a handgun only. Saucedo has an AR-15 rifle. Adrian, one of the first 5 in the building. Saucedo never goes in the building. After having line of sight, opportunity, and ability to do something, and he doesn't. He never goes in the building. And he also drives away, not towards the gunfire. But let's look at this. This is the dashboard of Coronado. Here's the sergeant. Mendoza's here. They set up perimeter. They're acting as if they're being shot at, but there's no evidence. There's no defects. There's no objective evidence they got shot at. Here's Saucedo. There's a long rifle. Watch his behavior. Watch him aim. And watch him do this point. He's there. He's there. There he is. He had aimed him. He saw him. He's pointing at him. He's there. And then they saw him walk into the building, so they leave. We're coming back to this video.
There's no evidence that's a misstatement of the facts, Your Honor.
No, it's not,
I'm going
Judge.
to object. I want it on the record that he's misstating facts to the jury.
Okay, once again, ladies and gentlemen, what they say in argument's not evidence. If it differs from your own recollection or rely on your own, you may proceed.
It's in evidence, guys. I asked questions. I was very specific about questions. I gave people opportunities to talk. I wasn't trying to be a bulldog on anybody. Maybe you can think I was on Ranger Hill, and we'll talk about that in a second. But we're just asking questions, specific questions, not general ones, okay? So let's talk about Officer Coronado, Sergeant Coronado. Adrian drove into danger. Sarge stayed away at the perimeter. Adrian, no line of sight. Sarge, same side as the shooter. Adrian, alone. Coronado has backup. Adrian, frantic witness he was dealing with. Coronado, frantic witness he was dealing with Claudia. Remember that? We're gonna look at the video again, and you'll see it. Adrian, unfortunately, and again, we're not ragging on her, okay? You saw me cross her, but she was wrong, and we'll talk about so many things that she was inaccurate about. A frantic witness that was wrong and inaccurate because she was on the wrong side of this issue. But the frantic witness, Claudia, the sergeant, on the same side, was accurate. Because you know why? Because she said, he went in the building. He went in the building. And you see the video yourself that they're acting like they knew he went in the building. Because you don't go from this, thinking you're being shot at, to this unless you know that the danger is gone and they're in the building. You saw the video yourself, and we're going to watch it again. Sergeant Coronado unfortunately drives away, not towards the gunfire. So now we're going to watch it again, but now we're going to focus on Sergeant Coronado, okay? This is him again. We already looked at Saucedo's behavior. Look who he's talking to. He's yelling at somebody, and that's Claudia. You go inside, okay, what? They're talking. She testified. I told him he went in the building. And guess what? He acts like he knew he went in the building. Because you don't go from ducking like that to watch his car drive off. Watch all of them. They all know he went in the building. They don't believe what they're trying to prosecute. There's no way. Our defense is not, well, if you're going to prosecute Adrian, prosecute other people. They don't believe it themselves. You can't. I'm going to go through a list in a little while of all the things that they're going to have to, Christina, with all due respect, is going to have to come up here and tell you to ignore to get to the man at the bottom of the totem pole. I'm going to show you that list, and I'll be right. Humbly, but I'll be right. Where's Randy Hill? I know it bothers them because he's the one dispatched. Why didn't they call him? Why didn't they call Saucedo? So we can ask them questions and bring you answers. The government has all the resources, all the rangers, this whole road. They have the whole government of Texas and all the resources to bring you evidence. And we expect that of them. Where's Randy Hill? Where's Mendoza? Where's Saucedo? None of them. The only reason why they brought Coronado is because they wanted that video in. He's dispatched at 11:29:36, 3 minutes before the shooter enters into the building. What was 911 told? That is another aspect of it, Bill. And Bill's right. I mean, he could hear. He's an intelligent man, and tremendous respect for him. But he heard our questions. I mean, that's a factor. If we're looking at the totality, what were they told? What information did they all have? Someone shooting a gun. This is what Mr. Limon is told, dispatch. They just shot at us. He's shooting at the school. That wasn't relayed to anybody. He's jumping into the schoolyard. Wasn't relayed to anybody. He's just jumped over the fence. Still wasn't relayed to anybody. He's running towards the school. Nobody knew that, but that nobody knew that includes Adrian. That includes Adrian. He's wearing black. No one knew that. That would have been helpful to know. But we know for sure, and I know Ranger Hill's here. He can come sit right here if he wants to. I asked him, you don't know when I know when he showed up on the scene. You do? It wasn't in your critical timeline. Well, it's in a different timeline that he gave to them, didn't give to us. Interesting. But so in his critical timeline that he didn't review for 3 years before he sat in front of you and testified to this, he said that that's all that's in his critical timeline, not when Randy Hill supposedly showed up, because Randy Hill didn't check in at location. Let me know what's going on. Nothing. No communication. So all we have in the first critical timeline is this. Randy Hill at 11:33:32. Just standing there. Said, did you hear how difficult it was for him to try to make up an excuse for what Randy Hill's behavior was? Did you hear how difficult it was? Because you couldn't objectively do it. Not based on Nico standards or Jason standards, just training standards, tactics. I asked them tactical questions. How does this make sense? Well, he was just there momentarily. Where's that? I don't understand where you're getting this from. What we know for sure is that Sergeant Coronado is driving around the school, and there's Randy Hill. He's already out of his car. He's been there for a little while. I don't know how much it is. The ranger thought he knew. I don't know how. But there he is, setting up perimeter when nobody's asked him to set up perimeter. Oh, they said there's a dispatch, again, that we didn't get from an unknown person. Remember that exchange? Figure it out.
Again, object. This is misleading the jury, and he's having them believe that we did not turn over everything to him, and it's
Okay. So
Remember that exchange? I was just asking questions based off the evidence that we were looking at. I let him, what are you looking at? So I can ask you about what you have in front of you. There was no trick question, no gotcha. I told him I'm not going to question your character, but I will question your opinion. I'm going to question your investigation. He knew that. He's coming before you after 3 years of all of this and the resources, 3 years, and that's what they brought you? That's the mortar to their case, Ranger Hill? Bringing it all together in this critical timeline? Well, where's Randy Hill? We all want to hear from Randy Hill. And then we have a hero, a true hero, Joe Vasquez. You heard about Joe. I mean, he gave me permission to call him Joe. He called me whatever he wants to, but we went through scenarios. We went through breaching. We talked about when you breach an outward swinging door versus inward swinging door. Well, what did Joe tell us? At 11:56:28, he linked up with Lieutenant Gonzales, who briefed him. Very different when you're being briefed by fellow cops after the situation has already been assessed. Very different, but they want to conflate that to Adrian. Well, they did that. They listened to instructions. They moved in. We have 27 officers around you. Everybody has guns and helmets and vests on and AR-15s and said, here's what's going on. And oh, yeah, of course they're going to listen. That wasn't Adrian. I asked if he wanted me to make entry. He didn't do. He asked. He understands there's an order. He understands the danger of it. We talked about the danger of it and fatal funnels, and there was two of them. There was the hallway, and then there was the actual doorway. We talked about that. Response, no, we're trying to negotiate because we've been fired at. That's what he was told. Waited with Canales for negotiating team and the tech team. So a true hero. I hope you like Joe, because I like Joe. I mean, he waited. There was still sporadic shooting at times. We look at the timelines, the critical timeline that's kind of complete. But he waited with Canales for the negotiation and the tech team. Should Joe be sitting in that chair? Is Joe a coward? Are board tack a coward? Are all the other officers cowards? Eventually, board tack showed up. It was a bit of a blur. He doesn't remember it. A lot was going on. Then they had a planning. They planned the entry. How long did you wait there? I asked them that. They entered at 12:50:01, almost an hour after he arrived. So Joe Vasquez is a real hero. He thought his daughter was in there. Could have been in there because she went to school there. But he still waited an hour because he knows there's a pecking order. He knows there's a way. He understands fatal funnels. He said, you're going to die at the door. That's what he said. We got that from Joe, not from us. And he waited because they were planning entry. Part of their training too. Waited 50 minutes, over 50 minutes. But board tap was rehearsing and opening the door. And again, I'm not saying that's good or bad. That's what part of their training, because an open outward swinging doors is difficult and it's dangerous. But they had the equipment at that time. Adrian didn't. The first 5 didn't. Taking cover is reasonable. Then we asked them about Adrian's behavior because they didn't bring an expert, so we had to ask somebody, and we're going to ask somebody who's in law enforcement. Well, taking cover is reasonable if you don't know where the shots are coming from. From Joe, their witness. Containment. Remember I asked about containment? We talked about that. And he said, if those first 5 officers, we call them the first 5, if the first 5 hadn't contained the shooter, he could have done the same thing to the whole school. Think about that. When he didn't contain, he didn't do anything to distract or detain or to impede. That first 5 group held them in 111 and 112. And let me submit to you humbly. If it wasn't for that first 5, that person responsible, because I know I've called him an animal and I know I've called him a monster because he is. You know, you get the point. But if it wasn't for that first 5, what would have stopped him from finishing off those precious babies in 112? Was it a distraction? He knew there was talking. There's negotiating. He waited for them. He wants to be a cop killer too. I mean, he wants to be a cop killer, so he's distracted. He's done damage he's done what he's done in 111. He did what he did in 112. But what would have stopped him to finish everybody off? The 5 outside, knowing that they could breach at any time. He doesn't know what they're doing. And he was waiting in that closet. He knows that closet, remember? 111 was his home room. He was going to 111. He went to school there. 111 was his home room. He knew that room. But even Joe Vasquez said, if those first 5 hadn't contained the shooter, and by the way, and I know it bothers them, Adrian's part of that first 5. And not that 3.5 minutes that Christina's going to come up and argue, that minute and 48 seconds with no line of sight. Talking to the guy on the stick. He was talking to the guy on the stick. Remember that stick is the stack when they're breaching behind the shield? He said he couldn't hear me because I realized I was wearing a gas mask. He himself was experiencing perception distortion. He didn't even realize he had a gas mask on. There was no gas, but he put it on and he couldn't hear. And he's talking like, oh, what am I doing with this gas mask on? And so he took it off to talk, but he didn't realize it at the time. But everybody, it's okay for everybody else except for Adrian, because he's the man on the bottom on the totem pole. He's easy pickings. Except for you guys to settle that. Now let's talk about Mel Flores. Look, I mean, if you couldn't tell that I had an affinity for her because she's a special ed teacher, then you weren't paying attention. I have a special needs son, and I told her that, and I appreciate that. And it takes a special person to spend 25 years teaching and taking care of and nurturing and stewarding special needs children. No one is attacking her character, but she came in almost 7 days after the event. She admitted she's watching these cameras and reading the stories and listening to talk, and that's human. That's normal. She wasn't given an order by the judge or anybody else not to talk to anybody, but that was influencing her talk. And so, but she's witness one. She's in their indictment. The training and then witness one, based off what she said. She thought the shooter had a handgun. She was sure of it, but he didn't have a handgun. Did not see the windows break on the east side of the building. I could not see from where I was, but Bill, in opening statements, expected you to say that she did. Why? Because that puts Adrian in a disadvantaged position. But then the truth came out during cross-examination, right? Remember we talked about that in jury selection? The greatest vehicle ever invented to find the truth, I was taught, is cross-examination. It's in Proverbs as well. Because we had to, and we asked you, and I told you that direct examination for the government was going to be like a waltz, and then cross-examination was going to be like a dental visit, pulling teeth, and I think you saw that. It wasn't our intent. We can't control the way the witnesses respond, but some of them were very honest. State Exhibit 921 identifies the wrong PD. She identified the wrong PD vehicle. She identified Sergeant Page's vehicle. She ID'd Donald Page. Khaki pants, Adrian didn't have khaki pants on. Full beard, Adrian didn't have a full beard. You saw the interview. Short sleeves, white short sleeve shirt. Adrian wasn't wearing white short sleeve shirt. We believe she saw Sergeant Page, but she also testified that she was frantic. Yes, I was. Let me submit to you respectfully. Again, this is nothing against Ms. Flores. God bless her. Let me submit to you that you heard the 911 call from Mr. Limones. You heard Amy Marin's 911 call. Understandably, it's frantic in the background. You heard Claudia in the background of Mr. Limones' 911 call. Ms. Flores was more like that. Adrian's dealing with that type of franticness. Understandably, again, it's not a criticism, it's just an observation. He was pacing. Remember we talked about that? Assessing because you're shouting, yes, they're shouting, south entrance, west entrance, shots fired. And we'll talk about when he transmits something in a second at 11:32:59. She was with Adrian from 2 to 7 minutes. You can't cherry pick what you want to believe from her, Christina. You just can't do that. Or you shouldn't do that. It's not right. It's not fair. I mean, so we know it couldn't have been 7 minutes because the timelines don't work out. The stuff that we do know, it couldn't have been 7 minutes. But even if it's 2 minutes, it covers the 1 minute, 48 seconds that Adrian had no eyesight on the shooter. He had no opportunity. He didn't have the ability. He's with her. She's a victim / witness at the time, yelling, frantic, giving instructions. He's taking shots. He's looking around. He's taking cover. See, it's okay for everyone else to take cover but Adrian. For a minute, he can't take cover for a minute to observe, orient, decide, and then act. Remember their training? But she's gonna have to come up here and tell you it's okay for Coronado, for Saucedo, and for Mendoza to take cover and then run from the shooting, run from the gunfire. Make a note, run from the gunfire, not run to the gunfire.
Your Honor, I'm going to object to the sidebar comment.
Sustained.
So she's going to have to argue that to you. And I don't know how you do it in good conscience. I just don't know how you do that. But
I have a quick question for y'all and put it in the comments below. Do you think that the prosecution is objecting so much because they're hitting a nerve and could cause damage to their side? Or do you believe that they're legitimate objections? Let me know.
2 to 7 minutes, it's a big deal. That's a big deal because it came out in evidence, and you should consider that. And the reason why it's in the big deal, I want to say this because I asked Ranger Hill, I said, well, why isn't that in your timeline? Why didn't you know that information? I go, would that have been important? And he said, yes, it would have been important. So good for answering that way, because it's true. It would have been important for him to assess critical, important, his definition, important timeline, 2 to 7 minutes with a witness / potential victim. It matters in your assessment of someone's behavior and what they didn't do and what they were actually doing. Excuse me. Shots being fired while with Adrian Gonzales. Yes, while they're together. So now he has somebody he has to protect as well. And himself and her, and think about it. He has no idea that this person's going, he doesn't know that. There's no evidence that he knew he was going in the building. He's going in the building, Adrian. There's no evidence of that. He couldn't even see this guy. And we said pacing could be taken cover. She says, I'm sure. Said the shooter went in the south door, but pointed to the west side. Yes, I did. And then in her interview, the investigator, the ranger, had to say he did not go in the south side. Oh, I really thought he did. And she was honest about it. I really thought she was mistaken. She just was inaccurate. At the time, he thought the shooter went in the south door. Yes. Told him the 4th grade building. He said, what building? He doesn't even know that. He's not part of that. He's assigned to the high school. He didn't even know which building you're talking about. Yes. I just wasn't listening, she said, because there was a lot going on for her. It's understandable. Then said he's on the west side of the building. Yes. So south side entrance, west side building. Yes. Dialogue between you two was 2 to 7 minutes. Yes. So here we go. Adrian with her 2 to 7 minutes. Shots being fired while with Adrian. Yes. You say pacing could have been taking cover. Yes. Said shooter went in the south. Yes. At the time you thought the shooter went in the south door. I did. Yes. Told him 4th grade building. He said what building? Yes. So there's confusion there. Not confusion like he's confused. He's trying to figure things out. He doesn't even know where she doesn't even know where she's directing him to. And again, there's a lot going on for her. Dialogue, yes. It just wasn't listening. Now we have Ranger Nick Hill. And I'm sorry, Christine, I didn't mean to be disrespectful to you. I apologize. I'm going to temper myself. I really believe, with all due respect, Ranger, I really do believe that Thomas Jefferson was talking about someone like Ranger Hill. And I'm saying that with him in the room. I consider trial by jury, you, as the only anchor ever yet imagined by man, by which the government, including him, the government, can be held to the principles of its constitution. And one of those principles is due process. You know what due process means? It means fundamental fair play. Fundamental fair play. Everybody gets it. Remember that blindfold? We don't do this. Doesn't apply to you. Can apply to you. Doesn't apply to you, sir. Applies to you, ma'am. It doesn't work that way. That's not how Lady Justice operates. That's why she's so beautiful. She wears that blindfold at all times. I'm not going to go over all of Ranger Hill's testimony and our back and forth. And again, if I offended you by my question of him, please hold it against me. I can only ask you to do that and extend some grace to me. But like Jason said, this was his presentation to you in good conscience. This was, and if you had not known any better, if we didn't ask questions, if we didn't push back, you would think that the shooter was right there and the angels just drove right by him. That's it. And then he placed the shooter where the shells were, and then we went through the whole ejection thing. Remember that? And it was at versus towards, and can you look at two people, and how many fingers am I holding up? We went through a whole bunch of stuff, and I just asked him pretty simple questions. But that's how he presented it to you, and that's not the facts. Jason told you. We know that because we have some video. Grainy, yes, we have video. But more importantly, we have Claudia, who he interviewed. He didn't review someone else's interview. He interviewed her. And not only does she, but also Mr. Limones and even Amy Marin loses the shooter in between cars. He's in between cars. That's where he should have been if he was going to present that to you, this animation. But the government sponsored him anyway. Now, whether they knew or didn't realize it, I don't know. I'm not inside their minds, and that's between them. But they sponsored him anyway. So what is Christina going to come here and say to you? 3 minutes. She'll say 3.5 maybe. Okay, because Bill kind of gave you the heads up on that. Didn't follow training. Well, Jason went over the training, so I asked him a lot of questions. I talked about tactics with him. He was a very, very nice man. He agreed. Just my opinion. I'm one opinion of many. There's different. These are suggestions. And I said, I understand. Thank you, sir. Very respectful. Didn't follow training. Then we showed you the training. We don't recommend going in alone. But we're not even saying Adrian made that conscious decision, by the way. We're talking about 1 minute, 48 seconds. Had an opportunity, best opportunity. I mean, Ranger Hill over the three in the corner said that Adrian had a better opportunity to stop that shooter than Coronado, Saucedo, and Mendoza. You're the judge of the credibility. That's why you're here. That's why I love the jury section, the jury trial. And here's what they're going to do. They didn't say it, but they're saying it. They're trying to feed you a coward sandwich. They want you to eat a big coward sandwich and say that Adrian's the one that gave it to you. The problem is, it is wrapped around 2 slices of bread of bravery. That's the problem. You have this coward sandwich, but you have bravery and bravery around it. The bravery of driving into trouble, thinking there was a shooter. Only one, didn't set up perimeter, goes into the trouble, into the eye of the storm. And then he's one of the first 5 that goes in the building. Takes rounds, what Martinez does, takes rounds, and you saw the video. Adrian has his weapon out. He doesn't move. Page is there. He's in the fatal funnel. All that shooter needed to do was turn this way and start shooting at them. He didn't run away. He only went outside when his radio didn't break, because the radios don't work inside of schools, which is interesting. And so then he had to go outside to call for SWAT, call for cover. Everybody's doing that. It's for the cover for the situation, not for him. That wasn't accurate. And then what Bill told you in opening is that Adrian, if you listen to Bill's opening, and again, this is respectfully, you would think that Adrian showed up and just stayed there and stood there. If you remember opening, I don't know if you do or don't, but that he just stood there and didn't do anything. And the evidence didn't play that out. The only thing Adrian remained in, he remained in danger. He went into the danger and remained. Once he figured things out, he went further into danger and remained. That's the only thing he remained in. And they're going to ask you to send the message. Jason couldn't help himself. He had to talk about it, and I understand. The problem is the message that will be sent is be Officer Hill. Set up perimeter, even though you're not asked to set up perimeter. Don't go in. Don't go into the eye of the storm. Don't even wait 30 minutes. Stand back. Don't do anything, because I don't want to be sitting in that chair. That's the message that will be sent. Not just to Uvalde County, but also to Nueces County, Bexar County, because people are watching. And that's the message that would be sent. That's not the message that needs to be sent. They need training. They need good training. They need proper training. They need resources. They need help from those schools to work with them in conjunction. And we'll talk about doors being locked here in a second. And they're all working synergistically together to protect the most precious thing we have in our community, and that's our children. No doubt about that. But to pick the man lowest on the totem pole and drag him into court and to come before you, there's a lot of things they're going to have to ask you to ignore. They're going to have to ask you to ignore inaccurate dispatch. They have to. I'm not saying it's their fault, but they're going to have to ask you to ignore it. They're going to have to ask you to ignore that Adrian drove into danger. Remember that sandwich? They're going to say, yeah, okay, the bread is fine, but the coward sandwich is full in the middle. And then, yeah, I understand the bread at the end is bravery, but we just want you to focus on what's in the middle. It's like an Oreo, you take off the up top, they want you to have the coward cream in the middle. Remained in danger. They're going to have to ask you to ignore that he remained in danger. That he had no line of sight. They're going to have to ask you to ignore that. He never had a line of sight, but other officers did, not him. They're going to have to ask you to ignore that it was truly, because I looked at the indictment and we're looking at the facts, it's truly 1 minute and 48 seconds. They're going to have to ask you to ignore that. She's going to argue something different, and give her your attention, please. They're going to have to ask you to ignore that. They're going to have to ask you to ignore Mendoza, who showed up 27, 28 seconds after Adrian. That's it. That's the difference. He was there too, before the shooter made it in, with line of sight, with backup, with guns, with superior weapons. They're going to have to ask you to ignore Saucedo. Line of sight, never goes in, drives away. You saw the video yourself on the dash cam. They're going to have to ask you to ignore Sergeant Coronado. They're going to have to ask you to ignore Randy Hill. They're going to have to ask you to ignore building doors being unlocked. Everybody, Wixel, all of them, all the Rangers said if those doors were locked, it would have made a difference. Since time is of the essence, those doors being locked would have made a difference, because you had 3 officers on that side. You had 3 officers on the side, on the west side, one with an AR-15, getting instruction from Claudia. He's going in the building. They're right there. And if you would have been locked out, you don't think that would have made a difference? But they have to ask you to ignore that. I don't know what you do with the school board on that. That's not what this trial is about. But you have to ignore that. They're going to have to ask you to ignore that. But it's not that important. It's more about Adrian. The classroom door is being unlocked. I'm sorry for what Mr. Reyes went through, but that door was unlocked, and it should have been locked. That would have made a difference, a key difference. And you know what really made a difference? If that door was unlocked and those 3 officers in the corner followed the gunfire and made it in the west door, not drive around for whatever reason. You can talk about, I want to hear the excuse. Made it, and then the shooter's in the fatal funnel. This door's locked, even if you got into the school. The classroom door's locked. And he starts shooting at the door, but then here's these 3 officers following their training, cutting the pie, getting with him, and then he's in the fatal funnel. That would have changed things. We can what if it all day long, but they're what ifing it, and they're asking you to make presumptions and speculate with Adrian, but they don't want to do it with anybody else. This is the hardest part of my job. Because I have to sit down and I can't talk anymore. It's not that I like talking, I just have a lot to say. I get it. You can ignore me, you can say I'm full of it, that's fine. You can tell me after. But because the state has, the government has this burden that Jason went over, the highest burden in our justice system, the burden that the government has to prove to take away someone's liberty and change the course of their family's life and that person's lives. And it's a burden that we all agreed was appropriate for the government with all their resources to have. They get to go first and they get to go last. They gave us that sandwich. They gave us the burden of proof sandwich, okay? It's the other way around. And so I have to sit down and I can't talk. And please give Christina your attention. And she's gonna make arguments to you. And you're gonna see me in the corner and I'm not gonna be looking at her, but it's not to be disrespectful. I wanna give her a heads up. It's because I get frustrated because I wanna talk and I got an answer and I got a question and I have an argument. That's just my personality, for good or bad. That's just the way God wired me, okay? But I'm gonna be looking down and be writing notes and my legs are gonna be going 100 miles an hour, I already know. But you can ask yourself, not just what would Nico, Jason, or Gary say, but what did the evidence show, right? And I promise you, I'm gonna do my best not to object during her closing. I will try. She can do it. I'm not offended by it. I'll do my best not to object, but listen to her, okay? And we're gonna ask you now, I'm asking you to apply this burden, the burden that's the highest in our justice system, the burden that says not sure is not guilty, the burden that says, no, you can't take the person from the bottom of the totem pole and move them up and ignore all these things. You can't ask me to ignore all those things, government. You can't. You can't ask me to ignore all those things and apply this high burden. The judge told you in the charge that if you have a doubt and it's reasonable, a doubt, one doubt, and it's reasonable, it's a not guilty. Just one doubt. Did they eliminate every doubt from your mind? I hope that's not the standard. If it did, then I'll deal with it. It'll be horrible, but I'll deal with it. But that would shock me. Because that can't be the standard. That can't be the standard. That can't be the message. Because she's going to come up and say, send a message. Well, but send a message also to the government. Send a message that, like Bill said in his closing, so we concentrated our case on the facts around Adrian Gonzales. Send the message you can't do that. You can't pick and choose. You've been given authority to steward well. People in our community say, steward this well, government. A huge responsibility. This is not how you steward it well. And if you apply the burden by law, if you buy the facts objectively, if you can acknowledge 2 things at one time, if you can acknowledge that families have been destroyed, because she's going to make an emotional plea to you. Everyone's cried, and you'll probably cry again. It doesn't take away something that my family's gone through or what they've gone through. If you apply them objectively and do what our founding fathers expected juries to do, we're asking you now, and we're hoping that you'll pick a 4-man or 4-person, 4-woman, and do a quick verdict, and a quick verdict of not guilty. Because the evidence has shown he's not guilty, folks. Thank you, and God bless you.
State.
Thank you, Judge. I just wanted to, just a quick note that the judge is going to decide the punishment. I think that was made clear to y'all, but I don't know if it was confusing here with the closing statement. So I guess I'll kind of address quickly the idea that I bow to political pressure. There's no evidence in this case that I bow to political pressure. And I think if you remember in the opening statements, the defense talked about all these third-party investigations that went on in the opening. And the easiest thing would have been me to do what all those did, which is say, don't blame us, blame somebody else, or everybody's to blame, therefore you can't hold anybody responsible. That would have been the easiest thing. So you know, I've never bowed to political pressure. And that's not what this case is about. The defendant, in their opening statement, they talked to you about, and they did here in the closing, that he was not assigned to the school. He relayed information. He drove to the school. He went into the building. He called for SWAT. He stood perimeter. He evacuated students. He had no shields. He checked on another officer. He got the building plans. He secured a master key. And there was even testimony during the trial that he evacuated students, and wasn't that a good thing? A good thing. And he relayed information over the radio, and wasn't that a good thing? Ladies and gentlemen, this is not about doing a good thing. I am not standing in front of you, and this case has not been about handing out participation trophies. That's not what this case is about. This case is about, and it's always been about, holding officers to the duty that's mandated for them in the law. Mr. Turner and I, as prosecutors, we have these big books that we're supposed to follow and the laws and all that, and he described to you that there's a special law in these books. One special law with regard to children. And that's what this case is about. All of this, the personal attacks, all of that was an attempt to justify the unjustifiable, in my mind. We're not talking about people being perfect. We're not talking about pretzels. And I'm not here to send mixed messages. I'm here to say that when you are a peace officer for a school district and you raise your right hand and say, I am going to be a peace officer, I'm going to do my job, that you're going to be held responsible. You're going to be held to that duty. You know, when we had the active shooter training that was brought in, that active shooter training goes through all the mass shootings of schools back to Columbine. At the time that the Robb shooting happened, we've had, 23 years of mass shootings. And school districts have begun their own law enforcement police force. That's saying, we're not just going to depend on the local police department. We're not going to depend on the sheriff's office. This school district, the Uvalde Independent School District, we are going to have our own police force. So what does that mean? That means these buildings, there are their homes. Those hallways, there are their roads. Those students in those classrooms, those are their people to protect. Even Mr. Gonzales, the defendant, says that in his video recorded statement to the Rangers. He says, it was a car wreck, but that's not my responsibility. That's the local PD's responsibility. But when I heard that there was a gunman and he was near the school and entering the school, that's when I got in and went, because that's his jurisdiction. That school district, that's his jurisdiction. Those students are his people. The charge that you have talks about the legal duty that the law enforcement is supposed to be responsible for. And then it talks about the Texas Education Code. And that's because our legislator had mandated that. And we cannot turn a blind eye to that. You know, their own expert witness talked about being in San Antonio and how he went into hot situations. Ladies and gentlemen, I would argue to you there's nothing hotter than a gunman in a school. That's pretty hot in my book. And we have training. And he said, if you have training or you don't, you figure it out. This defendant had training. He even provided the training. He put on the training. The defense would have you ignore all of that, all the things that they say that he did and that he's the low man on the totem pole. No, he's not. He's the top man. He was the police officer for the school district that showed up first. And why do we go back to having school police officers since Columbine? Because on any given day, you can have a monster that makes his way into your school. On any given day. On any given day, they would have you believe that because there was a wreck outside the school, that confused me. I don't hold me responsible because, the wreck's too much, so not my day. They would have you believe that on any given day where we have bailouts in the community, bailouts happen all the time. Even in large urban areas, you have people who outrun the police. But they want you to believe that because there were bailouts on this given day, but don't hold me responsible. Not my day, not my responsibility. They would have you believe that because he wasn't assigned to that particular school on any given day, don't hold me responsible. Not my day, not my responsibility. They would have you believe that because the doors weren't locked, it's not my responsibility. On that given day, the doors weren't locked, so not my day, not my responsibility. On any given day, I only had a pistol. He had a rifle, so it's not my day, it's not my responsibility. And then they would have us tell, the argument is because you had 3 other officers show up who believed that they were being shot at. Don't hold me responsible because on any given day, if you've got 3 other people that showed up, it's not my day, it's not my responsibility. And what strikes me so much in this case, and something that we believe the evidence has been brought to you that's going on and on, is the contrast in the training of the schools. If you think about it, since Columbine, the students have been taught, and you heard that, lock the door, lights out, be quiet. We are basically teaching these kids, and the kids in room 11 and room 12 were taught to practice for their impending death. You don't cry and you don't scream. But we're going to teach you what you do when a monster makes his way into the school. We're going to have you rehearse your own death. But yet, we have active shooter training that says to go to the fire that the defendant taught. But we're going to ignore that. Because on any given day, if he says, not my day, we're supposed to just look the other way. And I am sending a message. And I'm sorry if I'm repeating myself, because I want officers to know those days are over. We're not going to continue to teach children to rehearse their own death and not hold them to the training that's mandated by law. That when you hear the gunfire, you go to it. You go to the shots. You stop the dying, and you hold civilians, children, above yourself. You hold them, they're the highest priority of life. I think it's telling, and Mr. Turner touched this with you about the defendant's statement, and if you're going to get all the evidence to go back in there. He says in that statement, the teacher, she told me, he's over there, she pointed, he's over there, he's wearing all black. I think that statement is very telling because in that statement, he says on 3 different occasions, I walked over there. I walked to the school. I walked. And you contrast that with Miss Flores, and what is she saying? I ran, and I tell him, we need to get in there. We need to get in there. She's not saying you go. She's saying we, because in her mind, I believe you can infer that those kids and the protection of those kids are still tantamount to her. And there's no evidence that she had active shooter training. There's no evidence that she taught active shooter training. She was just a teacher. So are we going to continue to hold teachers and students to a higher level of responsibility, then we are going to hold police officers for school districts who raise their hand and say, I will be a police officer. Those hallways will be mine. Those children are my people. Those classrooms are my houses. I will protect them. Are we going to continue to do that? No. Because on any given day, you can be like Mr. Salinas and Ms. Torres, who came in and testified to you. They dropped their children off for school that day, and the next time they saw their children, it was at the hospital. Mr. Salinas told you that the child that he dropped off for school that day is not the same child he picked up. Because on any given day, a monster can make his way into an elementary school. Ms. Garcia testified that she dropped her child off at school, she went to the award ceremony, and her daughter wanted to come home with her. And she said, no, I paid $2 for that pizza party, you're gonna go and have a good time. And then she never saw her daughter again.
How many of us mothers have said that? I paid that $2, child, you're going to go. Oh, and now the guilt and the grief. Lord have mercy.
Because on any given day, that can happen. We know that. We see it. Nueces County is not any different from Uvalde County. It's just not. What happened to Uvalde on May 24th can happen anywhere at any time. And if it's going to happen, and if we have laws mandating what the responsibility of a law enforcement peace officer is for a school district, then we better be ready to back it up. You had the teachers come testify to you about what was going on. And what do we know about what the defendant had versus the children in rooms 111 and 112? The defendant had his car. It was on the corner building. He had cover. What do the children have? They had chairs and desks. Defendant had a pistol. What do the children have in rooms 111 and 112? They had unarmed teachers. The defendant had a vest on. And what do the children have in rooms 111 and 112? They had curtains to hide behind. I would also, if you get all the evidence back, that you listen to the defendant's statement. And I think it's always telling, is when that ranger asked him, why didn't you engage? Why didn't you go and approach? And the look on the defendant's face is like, not me. Really? I mean, it's like he catches himself because it wasn't his day. On any given day that this monster made his way to Robb Elementary, that wasn't his day. You heard a lot about the time compression, the auditory exclusion, the fatal funnel, the OODA loop, echoing. You even heard about a fatal field. Because we all know on any given day, there may be a fatal field. And we have to be ready. You're going to get all the evidence behind you, sent back with you, and you'll have the radio traffic, and you can look at that and decide if it's 1 minute or 3 minutes. But even a minute and 48 seconds, what he put up here, a minute and 48 seconds. I don't know if anybody just sat still for a minute and 48 seconds. That's a very long time to distract, engage, and delay. And his backdrop was right here. All you had to do was to even attempt to distract, delay, or engage. I know this case is difficult, and it has been difficult. But we cannot continue to let children die in vain. We cannot. New Oasis County is not any different from Uvalde County. We cannot let 19 children die in vain and another 10 to suffer. They're going to be that suffering for a long time. On behalf of those 19 children, I respectfully request that after your deliberations, that you return a verdict of guilty. Thank you.
Okay, ladies and gentlemen of the jury, you will have the charge of the court back there. You'll have the evidence. I will ask you to deliberate and give us the word when you have a verdict, and we will alert everyone and give time to get people back in the courtroom, and we'll bring you out and receive the verdict. We're going to have lunch served in the jury room for you. You're welcome to deliberate while you're eating lunch. And could I ask the three alternates to remain? We're going to have them go back, and I'll talk to you further. Okay? So let everyone rise for the jury.
I'm going to go ahead and start the clock.
One more time that the evidence goes back correctly.
Okay, we are in lunch break in one court, jury watch in the other court.
Courtroom.
Here's the poll. Oh, my crunching is coming through. My bad. Okay. So now we have both courts. One is on a lunch break. The other court is on a verdict watch. What are we going to do, y'all? We got an hour to kill. I'm trying to pop my eardrums. This one don't want to pop and it's hurting. Let me see what I can find on YouTube. Give me a second. I'm going to turn off that volume because I know it's getting ready to go. Give me a second. There's another trial that's been going on, but I have no idea. I have known nothing about the trial. It is the Paul Canario Day 6 Madison Red Room trial. We can watch that. June, what do you think? We can. I'm looking. That's about the only thing that's on. That is about the only thing that is on right now. Let's see what's happening in that court. They're on lunch break. Grr. All right. Do we want Judge Boyd or Judge Simpson? Let me see Boyd. Let's see. We'll see what's going on in Miss Judge Boyd's court. We can hold individuals accountable, but until these meaningful reforms, this will keep happening. Probably so. Okay. All right, let me get this playing. Let me get some sound on this.
Is in compliance with discovery. Mr. Smith, in each cause number, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, in each cause number, do you waive the reading of the indictment?
We do, Your Honor.
State, in the cause number ending in 6-5, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
And in the cause number ending in 3-6, are you proceeding on the indictment as presented?
We are not, Your Honor. We are proceeding on count. We, on that one, we'll waive counts 1 and 2. No objections, Your Honor.
And Mr. Smith, in each cause number, did you review the application for deferred or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
In each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? And cause number 2025 CR 014065, you're charged with violation bond or protective order 2 times or more within 12 months. And in cause number 2025 CR 014136, you're charged with stalking. These are third-degree felonies. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. That you intend to give up those rights and enter into pleas in each of these cause numbers. In each cause number, did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you to 10 years in prison in each cause number and up to a $10,000 fine? Did you understand? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Smith, in either of these cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, and re-entry. Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes.
In cause number ending in 6-5, according to the plea, punishment is to be assessed at 6 years in the prison. There's a $1,500 fine. State is opposed to your applications. This will run concurrent with the case number ending in
Now that you said, I think I need to fix that.
all right. Any objection to the court just correcting that?
Yes.
All right,
Objections.
no problem. This is the run concurrent with 2025 CR 014.
That woman catches everything. It amazes me how smart she is. And by the way, how do you like her new haircut? Got a new haircut, y'all.
One 136 and 2025 CC 014639. The state is taking in consideration 2025 AL 001293 and 2025 AL 002994. And there's to be restitution, if any. And there's to
Personal information they've gone quiet on.
in the cause number ending in 36. The state is proceeding on count 3. Punishment is to be assessed at 6 years in the prison. There's a $1,500 fine. State is opposed to your applications. This will run concurrent with 2025 CR 014065 and 2025 CC 014639. They're taking in consideration 2025 AL 001293, 2025 AL 002994, restitution, if any, and the same no contact orders. Did you understand that to be your plea in each of these cause numbers? Defense is at the plea?
It is, Your Honor.
State is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney in each of these cause numbers? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
There have not been, no.
Then in clause number 2025 CR 014065, how do you plead? Guilty, not guilty, or no contest?
No contest.
To count three in cause number 2025 CR 014136, how do you plead? Guilty, not guilty, or no contest?
No.
State any evidence.
Mr. Chairman, with regard to both cases, state will offer into evidence if exhibit one, public fact. No objections, Your Honor.
All right, and state, have you spoken with the complainants? All right, thank you. State, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? In each cause number, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
I love the fact that she actually reads this stuff. She actually pays attention. And she's caught many mistakes doing this. Some judges just kind of accept it and move on. But anyway, y'all doing okay today? Y'all ready? Who's going to get, by the show of hands, who's going to get a bunch of snow? We're not going to get snow, but we get a lot of ice. And when we get ice, power lines come down. I will most likely lose my power. Hope I don't, but I just might. You coming back on, Miss Judge Boyd? You still reading? Y'all hear my crunchies? I am definitely going to go this summer, but this spring when we have a day or two off. I'm going to go to Miss Judge Boyd's court, and I'm going to be sitting in back there. I have our mods put us live, and you see me back there in court. But I want to find a cool trial that she's got coming up.
In each cause number at the review and states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt in each cause number as you apply for deferred adjudication. All right. Counsel, if he wants a full TSI, it's going to be about 8 to 12 weeks. If he would like to come back sooner, if you waive PSI, what will end up happening is I'll give you a chance to have whatever witnesses or whoever you want brought in to testify or whatever evidence you want to present to the court. But otherwise, it'll be 8 to 12 weeks for a PSI and TAP evaluation.
Mr. Smith is very motivated to get out, so the sooner the better. And yes, will there be any, you'll just have some confirmation of his record or anything from the PSI?
The state will probably most likely give me any type of criminal history. But what I can tell you all from reading the stipulated evidence, do you think he needs a MIC evaluation at least?
He's a veteran, spent 4 years in the military.
Mhm.
And on a particular date, I don't have the date in front of me, Your Honor, he had a motorcycle accident, which is case is pending.
Mhm.
So there was a TBI involved. So I have a volume 1 of his medical that I was going to try to succinctly place before Your Honor.
Okay.
And the better news is he has grandparents who are here present. They've been very active through the case this entire time, very supportive. If we were to be granted probation, he would reside there. Immediately the same day or the following day, he's going to be in with the doctor to get the appropriate medication to assist his situation. And will have the resources, we think, based on the
Do you think Judge Boyd is believing this guy? Look at her face. Do you think she's believing it?
accident resources that we think we're going to get as a result of the traumatic brain injury accident. And so none of these things are going to occur in the future. He's going to be a stable resident. He's going to receive the right medication. He's going to have just a new outlook. He's been, very remorseful about this whole entire situation and what he did. And, he realizes the situation he got himself in. He spent almost a year in custody and he's just very motivated to get out.
Okay. So, that's information you may want to let the state know. So do you want a MIC evaluation? If there's a MIC evaluation done, how long would that still be? 8 to 12 weeks?
Judge, I can probably get it done in 6 weeks.
Give me one quick second.
Sure.
So she's all like, boo, I ain't believing it, but go ahead and do your NIC eval. That all goes in there. I don't need that information right now. What I need to know is 1, yes or no. Do you want to do a NIC eval? Other than that, we are good to go, boo.
Thank you, evaluation. We've already, in the volumes of information I have, there's already been an evaluation. That'll be some of the testimony that we'll provide to the court. So we could have just a shorter time frame, maybe a few weeks before we come back.
How long would you request
In terms of
time for us to come back?
3 weeks or so would be fine, and then I'll get a packet ready for the court and the DA for that day.
All right.
And we probably need about 15 minutes in terms of court time with the grandparents to testify.
Is veterans treatment for an option?
We can do yes, I think we should probably see about Veterans Treatment Court.
I just text to see if someone can know.
Okay.
Okay. All right.
So they have a
Ms.
veterans-
Ferguson, I need a date.
There is a new thing that's happening across the nation in a lot of states. And Judge Boyd, I love the fact that she uses it as she does. It is a veterans treatment court. It is a court that is designed solely for the veterans to assist them in their situations, depending on what crime they have committed. So, yes, I'm so glad to see that they actually have a veterans court. Just like they have a drug court, now they have a veterans court.
Well, you know what? Let's not do a date yet. Let's confer. You confer with Veterans Treatment Court.
Okay.
Just have a seat and then we'll come back and I'll give you a date. But I'll note for the record that you're waiving PSI and TAP evaluation.
Thank you.
All right. So just have a seat and they'll be up here. Anyone else ready? Vincent Munoz. Hello.
Good morning, Your Honor.
Good morning. Sorry, I'm just marking a couple of things off. Are there any applications?
Well, on the
For
burglary is being reduced to a misdemeanor.
Okay,
On the MTR, we're going to open on the MTR.
okay. All right, then we'll start with the burglary. The court is calling 2025 CR 014998, State versus Vincent Munoz. Could I have parties announced for the record for the state?
David A. Garcia, attorney for Vincent Munoz, Judge.
And are you Mr. Munoz?
Yes, ma'am.
Counsel, in that cause number, have you received all discovery? Did you
By the way, MTR equals motion to revoke.
review it with your client?
I have and we have.
Court will find that the state is in compliance with discovery. Mr. Munoz, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented? Any
No
objection?
objection.
Did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, the state is proceeding on the lesser included offense of criminal trespass as a Class B misdemeanor. The range of punishment is up to 180 days in the Bexar County Jail and up to $2,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses, and the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do and he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Mr. Munoz, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your
Did you understand if you're not a U.S. citizen, by entering this plea, you may be deported, denied naturalization, and reentry?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of criminal trespass. Punishment is to be assessed at 114 days in the Bexar County Jail. There's an $800 fine and no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Sure.
Counsel, there be any such motions?
No, Judge.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
We've reviewed states one and all attachments, Your Honor. We have no objections.
All right. Mr. Munoz, did you review the document entitled Waiver and Stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
And now she does a review. I love this woman. She's so good. Okay, we do have some. Do y'all want to watch this at all? Put yes or no if you want to watch the court TV little filler blocks that's going on, or do you want to watch Judge Boyd? Do you want to watch this? Put CTV, or you can put Boyd.
Attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, regarding the misdemeanor that he's pled to, we're just asking that you go along with the plea bargain and that it run concurrent with whatever ends up on happening on his FDR.
Will sentence you to 114 days in the Bear County Jail, give you credit for any time served. There's an $800 fine, time and money to run concurrently. With regards to sentencing,
No, Judge.
and I'm so sorry, and this will run concurrently with all right, 2024 CR 1361.
Yes.
All right, on that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
We're moving on to cause number 2024 CR 2024 CR 1361. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Vincent Ambrose Munoz, who was placed on deferred adjudication in 2024 CR 1361 for the offense of abandoning a child criminal negligence on April 9, 2024 for a period of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Violation of condition 4 and Texas, the defendant Vincent Ambrose Munoz did and there failed to report to the supervision officer as directed for the month of June 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And the abandonment.
No objections.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility
Yes.
and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There's not the ultimate motion and revoke his community supervision and sentence him to 2 years in the state jail facility.
All right, in defense, what are you requesting?
Judge, we went open so that my client would have an opportunity, one, to be reinstated, and if in the alternative, to see if you could be a little bit more lenient than the state. He faces 2 years state jail. Clearly, he made a lot of mistakes. Probation's recommending revocation.
Mhm.
State's recommending revocation. He just pled to a burglary that was reduced down to a criminal mischief. He made a lot of bad choices. He was close to finishing one of his classes, and then the burglary arrest occurred. Doesn't excuse what happened. He made a bad mistake to go someplace with who's now the mother of his child.
Seems to me he's making a lot of bad choices and not just one. I wonder what Boyd's going to do with this. Comment below. Do you think he's going to get the max or is she going to give him the minimum? Do you think she's going to side with the state or the defense? Because I got to tell you, he's made a lot of bad choices.
Mother of his child to be. She's due in 4 months.
She's due in June.
In June.
5 months.
5 months. He
What
should.
did you do when that criminal trespass occurred?
No, we found out she was pregnant when she was incarcerated.
Okay.
She got arrested with him
Oh.
at that instance. She was, our understanding was the main aggressor at the door, but the state reduced her case to a criminal mischief, and they did so with my client. He understands he made that mistake. He should have never been there. They went there to get the clothing for Kimberly's children, not his child, correct? But nonetheless, it was a bad mistake to go. He understands that. That's why he took this plea. He understands he had been making a lot of mistakes on his probation, but while he's been sitting in jail, Judge, he's tried to turn his life around. You saw the certificate of completion for the child class, the fact that he's been going to meetings. He's really been trying to change things for himself, even though he understands he made a mistake and it's a grievous mistake. He's throwing himself on the mercy of the court, hoping, one, you reinstate him. He's got a job waiting for him. He's got this baby coming in 5 months. And if not, he understands, but he's hoping you give him a more lenient sentence to 6 months in state jail or a year so that he can do his time and get back to his job and help raise this child and move on in his life.
So what has he done on probation? Has he done anything?
I did,
Want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Munoz.
All right. What have you done on probation?
I completed my first class with the driver safety course. I was right before catching this charge. I was one class away from finishing my parenting class. Then after that, I was going to start my AA. I was showing up to my meetings and everything, but I didn't end up showing to my drug testing because money was tight, but also I didn't have a reliable transportation. But my sister has an extra car that she paid off and got her new car, so she told me that.
No excuse.
Hopefully, willingly that she has another car for me so I can have reliable transportation and show up to my meetings, drug testing, my job, and classes or anything that I need to do to be responsible for myself.
All right, any questions, state?
Or yes, Judge.
No problem.
Hey, Mr. Munoz, so when you were placed on probation, you provided the probation office with an address of 15800 Chaseville Boulevard. And then it was apartment 310 bed. Do you recall that?
Yes.
Okay, whose apartment was that?
That was my ex-stepfather's.
Okay. And so one condition that you had in your probation, I guess it was amended later on, was that you were supposed to reside with your mother at 2503 Jackson Keller Road. Do you recall that?
Yes.
Okay, and so at the time that you were arrested for this charge that you just pled to, the
Criminal trespass.
you were not residing with your mom, correct?
Yes, ma'am. It's because they ended up splitting up.
Who?
My mom and my ex-stepdad.
Okay, so if I'm understanding correctly, that address at Chaseville Boulevard, so your mom and your stepdad were living together there, is that correct?
No, Chaseville Boulevard, that was
Your stepdad's address.
no, the stepdad address was 2503 Jackson Keller, and Chase Boulevard, I was staying with my partner's friend. She helped us roommate there, but I had ended up
I used to live off of Jackson Keller.
telling my probation officers because I had nowhere to go.
Saying.
My last option, because I was throughout this time I was back and forth through hotels and motels.
Okay, and so you were not residing with your mom, you were residing with Kimberly and then the friend that was helping y'all.
Yes, ma'am.
Is that fair to say?
Yes, ma'am.
Okay, and then regarding your urinalysis, you were instructed to provide samples multiple times. If we're looking here, 9 times, you recall that?
Yes, ma'am.
Okay, and you didn't show up to provide UA 9 times.
Yeah, it was like I didn't really have too much reliable transportation, and it was just where I was staying at, my mom and people, it just didn't match their time schedules, what they were working, and I was trying my best, and every money that I did had, it was either helping out on rent or going on.
Okay, so help me understand this correctly, because you're saying that you have reliable transportation to go provide your analysis, correct? However, on the day that you were arrested for criminal trespass, you and Kimberly were in possession of a Dodge Durango, correct?
Yes.
And you all drove over to Dionisa's address, correct? So you have reliable transportation to go commit other crimes, but not to comply with your probation. Is that correct?
Yes, but I had just asked my sister if I could pick up her stuff. That was that extra car that she was that I was speaking of.
But she couldn't provide you help to comply with probation?
It was, she had just got a new car about the beginning of September. So at the time when I did ask her, she was like, she didn't really want to let me use it, but she was just like, I just needed to get his clothes.
And then you stated that you completed the aggressive driving course, is that correct?
Yes, ma'am.
And probation was provided with a copy of that.
Yes, ma'am.
Okay, but you were also ordered to do your sober support meetings and parenting class, and the parenting class is something that you completed while you were in custody after being arrested, is that correct?
Yes, ma'am.
Okay. And then the one time that you did show up to UA in July of 2025, you were positive for marijuana, correct? And so you're here asking this court to be lenient on you, is that correct?
Yep.
But you have not provided any evidence to this court that one, you deserve leniency, or two, that you ever intended to comply with probation. You agree with me, right?
That's right.
You have to witness.
Any further questions?
Just a few, Judge. Vincent, you sort of glommed over the fact that you didn't show up to these UA tests because of transportation, correct? Was financial, and the financial aspect also a reason you didn't show up?
Yes.
Explain that to the judge.
A lot of money that I had saved up was going towards hotels, and I didn't really have nowhere to go. So that was mainly where my money was going at, and I didn't really have a car, so I would always use Uber to get food or something like that.
And you're not trying to tell the judge that you have an excuse for everything, correct?
No, I take full accountability for my.
So you understand you did very poorly on this probation, but you're trying to explain why. It was, a lot of it was financial. And so you would show up to meet with your probation officer, they would tell you to show up for a urinalysis test, and you told them you didn't have the money, correct?
Yes.
Because it costs every time you show up to give a urine test.
Yes.
And so and you pled true to not showing up because you didn't, right?
Yes.
So even though you messed up on your probation, you were trying, correct?
Yes.
And you almost finished that parenting class through probation, didn't you?
Yes, I was one class away.
Okay, and then you got arrested because of another bad decision, right?
Yes, sir.
But while in jail, you did complete the parenting class.
Yes, sir. And then I started my AA classes as well.
Okay. If the judge grants you this opportunity to stay on probation, can you promise her, in spite of financial reasons, you'll make every meeting, you'll show up and you'll be clean?
I promise, and I do stand on that, as well as as I told her, I have reliable transportation. I talked to my grandma here a lot too. She put about $300 aside for me for my drug test. Kimberly as well. She has a few checks that she had saved up while being in here. She told me as well she could help me with my restitution fees. And when I get my job, I can end up finish paying it off and then just do my AA classes. That's the only class that I have left.
No further questions, Judge.
All right, any objection to the court asking some questions, or State, do you have any questions?
I don't have any other.
No objections, Judge.
Since 2024, when you were placed on this probation, have you ever been employed?
I was working under the table most of the time with painting. And then I ended up, when I got arrested in October, and then when I got out, it was hard for me to find a job. But then I ended up finding a job and I was working about 3-4 months. They let me go. They were letting a lot of people go, but I was working under as a temp for Pacific Seafood. And then from there, I was working with my grandmother. She does events downtown, so I would work every weekend about selling food, setting up the booths, doing that. But while being in here, my mom has a job, and she ended up talking to her supervisors and her team lead, and they said that they have a spot waiting.
All right. And then did you tell probation that you would no longer be able to reside at the listed location?
Yes.
And that was ordered by another judge?
Yes.
When did you tell them you would not be residing at that location?
When I went to one of my probation meetings, I told her that my ex-stepdad and my mom, they ended up splitting up, kicked us out, because he has a new partner. And then I ended up going with my grandma's house, and then Kimberly ended up getting pregnant about 2-3 months while I was there.
All right, why do you say, I don't like when people use the term ended up getting pregnant. Were you not a part of that?
No, yeah, I was. My fault.
So, I mean, everybody knows, I'm assuming, how old are you?
I'm 27.
All right, people know how babies are made. So you all
We both,
decide or to have a child.
she ended up being pregnant at that time, and my grandma didn't really, I think because of me getting locked up last year, it was a situation due with her. They didn't really get along too much, so when she had ended up finding that out, she told me I had to leave. So I was staying with her at 6818 Senor. I was there for about 2-3 months. Her and her mom ended up getting into it because she had a miscarriage. Then from there, that's when we were staying at hotels and we were just trying to find somewhere to go. And then I asked my grandma if I could stay there again. My uncle ended up moving in. He was just like, I don't want nobody living here because this is gonna be my house pretty soon. And I had nowhere to really go. And then while she found her friend, we stayed at Chase Boulevard. She was letting us stay there. And then right about the ending of September, my sister told me that she ended up getting an apartment. She got another car. She was like, if you do end up not staying there, y'all can come move in with me. And then all this ended up happening.
This is what I don't understand, and maybe you can help me understand it. Why is it that people, they don't have a place to stay? They don't have a stable employment, and they decide they're going to bring a child in the world and they can't even support themselves. And everything that you've told me, and I listened to your answers to the questions, everything that you've told me, you're relying on somebody else.
How did I know she was going to bring up? She always preaches that if you can't take care of yourself, don't bring somebody else into this world.
Kimberly has money that she's been saving up since she's been in custody. Somebody else has money, your grandmother, they've been saving up money. And if neither one of them give you that money, we're going to be right back here.
Well, I have that job waiting for me, so I'm willing to work with that. My mom told me they paid from 17, 18 an hour, and I'd be working 3 days a week. So I'd save up all my checks and just pay what I need to pay off myself, take care of my responsibilities.
Any objection to the court reviewing the court summary?
No, Judge.
Any objection? Have you read the court summary?
Yes, Your Honor.
You want to find interesting that the verdict watch for Court TV, I started it the moment they walked out of that courtroom 40 minutes and 35 seconds ago. Theirs has 42 minutes. That's interesting. But we are at 42 minutes into the verdict watch.
All right. After reading the court summary, probation is basically saying you were never compliant. They said that there was a previous motion to revoke, and this was with a different judge. They say following a motion to revoke filed on October 31st, 2024 for a new offensive assault, his conditions were amended on January 9th to require weekly reporting indefinitely and
All right, Miss Red Panda Power. Good to see you, beloved. We're watching Judge Boyd because we are in lunch break until 12:05. 1:05 my time, about 10 more minutes. In the Brendan Banfield trial, we'll go to that when it goes live. We're in verdict watch right now for the Gutierrez trial. We are currently, I have 42 minutes in. I started when they stood up and dismissed the jury, so we're about 30 seconds or half a minute off from Court TV, so we're about the same. Good to see you, Red Panda Power. I hope you're doing well. I hope you're doing good and keeping up with your schoolwork. Back to court.
residency with his mother. It says, despite these directives, the probationer refused to reside with his mother, citing conflicts, and instead stayed temporarily in a hotel before moving in with his grandmother, failing to provide proof of residence. He has remained unemployed, completed only an aggressive driving course on May 20th, 2025, and otherwise made no progress or required parenting or other classes. He has paid only $38 towards his fees, leaving a delinquency of $1,412. And see, I understand when people can't pay money, but from 2024 to only have paid $38 towards your fees, that's sort of not really trying. And they say his reporting has been inconsistent with frequent failures to appear and intermittent walk-ins, and field visits were often unsuccessful due to his absence. A manager hearing on August 22nd, 2025 documented his continued noncompliance and failure to pay fees, during which he was encouraged to obtain employment. Despite these interventions, he remains noncompliant. Yeah, I don't think probation is for you. I'm going to grant the motion. I'm going to find you guilty, revoke. This will run concurrent with 2025 CR 014998. The court will sentence you to 20 months in the state jail facility, give you credit for any time served. And I'll ask for the therapeutic community. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign?
Yes, Your Honor.
All right, do you have a limited right to appeal? The right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. And I want you to know your attorney did do a great job, and I did listen to everything and internalize everything. But sometimes, you know, you're just not doing well on probation and there's nothing I can do. Okay.
Yes, ma'am.
All right. Good luck to you. Okay.
Thank you.
All right.
Wow. I'll check on you, do.
Yes. Does she has someone on the docket phone? Oh, excuse me. No, that's not what it is. Could you speak with, Ms.
Megan?
Galloway?
I
on
did.
that? Yes.
I did. And I told her that I would speak to him to see what after I explained fully to him what the potential was.
Okay.
He decided that he would like to try and get probation.
Mhm.
So I went ahead and filed the motion for new trial. I have given her a copy of that. I assume she's just going to oppose it. So whenever the court wants to set it, that's her.
Oh, just said it. I don't know. She may not oppose it.
I think he deserved the 20 months because, dude, he hadn't done anything. Nothing but excuses. I would have been her. That would have been me.
See his criminal history. I know he said he only had theft cases.
Right. I told him that you had not seen the full spectrum yet and that might affect the outcome, but he wanted to try.
Okay. And then what I can tell you is if okay, so if they do that, then we'll take care of it.
That'd be great.
Okay.
Yeah, that will work. And whenever the court wants to set it.
Oh, just talk with Ms. Ferguson.
Okay.
All right, on Smith.
Judge, unfortunately, he will be ineligible for felony, veterans treatment court.
All right, Norma, on Dominic Smith then, let's set this, when his attorney comes back, see if 3 weeks is okay with him, when to call this or whatever he wants it set for. All right, is there anyone else ready?
That's the same for Judge.
Lennon Cortez. Oh, is Charles here? Okay. All right, thank you. Let me see real quick with this and then I'll go to the next one.
The judge will come back tomorrow on all that.
All right, thank you. All right, Charles, you ready?
Yes, Judge.
No problem. All right, the court is calling 2025 CR 011541 and 2025 CR 01145.
Trying to see what is on his shirt, and now I see it's a face, but I'm trying to figure out, is it the Godfather?
2, State versus Lennon Cortez. Can I have
Love
parties
it.
announced?
State.
Charles Blunt for Mr. Cortez.
And are you Mr. Cortez? Counsel, in each of these cause numbers, have you received all discovery and did you review it with your client?
Yes, Judge.
In each cause number, the court will find that the state is in compliance with discovery. Are there any applications?
No, Judge.
In each cause number, Mr. Cortez, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, in each cause number, do you waive the reading of the indictment?
We did.
State in each cause number, are you proceeding on the indictment as presented?
The cause ending in 4-2 state moves to proceed on the lesser included offense of possession of controlled substance, PG2 less than 1.
No objection.
All right, in each cause numbers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? In the cause number ending in 4-1, you're charged with unauthorized use of a vehicle. And in cause number ending in 4-2, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 2, less than 1 gram. Those are state jail felonies. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering into these pleas, you're giving up those rights? And did you intend to give up those rights and enter into a plea in each cause number? Counsel, in each cause number, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yeah.
Mr. Cortez, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
In each cause number, if you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Off the record for a moment. So on the plea bargain, I'm sorry, I'm having a bit of trouble understanding the time.
It's
on the
it's 12 months.
41. Okay, so that's 365. It's just that it was, so it's 365 in each.
Yes.
Okay. All right, we're back on the record. In each cause number, according to your plea bargain agreement, punishment is to be assessed at 365 days in the Bexar County Jail under 1244. There's an $800 fine. The cause numbers will run concurrently. And then the cause number ending in 42, state is proceeding on the lesser included offense. Did you understand that to be your plea? Defense?
Yes, Judge.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney in each cause number? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there many such motions?
No, Judge.
Then in 2025 CR 011542, to the lesser included offense of possession of a controlled substance, penalty group 2, less than 1 gram. How do you plead? Guilty, not guilty, or no contest? No contest. And cause number 2025 CR 011541, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Judge. Reference to exhibit 1 in all.
No objections.
All right, state, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
And they're the same report in both cases, Judge.
Okay, thank you. I'm just looking for the lab report. Ah, it's labeled. I love when it's labeled. All right, in each cause number, the court will find that there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
We believe he's worthy of the plea bargain. We ask you to follow it.
Odyssey is a little bit slow. And cause number 2025 CR 011541. As previously stated, the court is finding you guilty. Court will sentence you to 365 days in the Bexar County Jail under 1244. Give you credit for any time served. There's an $800 fine. Time and money will run concurrently. And this will run concurrent with 2025 CR 011542. And is this a judgment satisfied or no?
No, Judge.
Is there anything else with regards to sentencing under that clause number?
No, Judge.
Next, we'll proceed in cause number 2025 CR 0115 I'm sorry, that last cause number, court reporter, was that 542?
The last one was 541.
All right, thank you. Then the next cause number we'll proceed in will be 2025 CR 011542. And in that cause number, as previously stated, the court will find you guilty of the lesser included offense of possession of a controlled substance, penalty group 2, less than 1 gram. Court will follow your agreement, sentence you to 365 days in the Bexar County Jail under 1244. Give you credit for any time served. There's an $800 fine. Time and money will run concurrently. And this will run concurrent with 2025 CR 011541. Is there anything else with regards to sentencing under that cause number?
No, Judge.
And each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
No.
All right, we can go off the record. Here's the thing. At the jail, I know sometimes people think they're getting 2 for 1 or 3 for 1. I'm not in charge of 2 for 1 or 3 for 1. So if the jail decides not to give you credit of 2 days for every day you spent, you can't come to me for that because I have no jurisdiction over that. The only thing I can tell you is I've sentenced you to 365 days, and that's my sentence. You understand? All right, good luck to you.
Thank you,
Thank you,
Judge.
counsel.
Just have a picture.
Megan has it. Sure. Yes.
So I have David Crenshaw did.
Yes.
I conferred with the state. They've made a new offer.
Mhm.
I want to see if we can get a reset so I can go through some things with my client. Was sitting right here with the glasses.
All right, just 1 second.
There's a poll posted in the Gonzales trial. Poll posted in the Gonzales trial.
All right, so he's already had his plea deadline date, and I know they've entered a new case, but I need to know something today because his next setting is going to be a jury trial date. Because this was set for a plea deadline date on January 20th.
Yesterday.
Yes. So,
Why don't we go ahead and set it for trial, Judge, with motions to suppress?
okay.
The state's going to hold that offer open for one more time, but we'll either work it out or we'll.
Well, I mean, the court is telling everyone the plea deadline date will have expired.
Right.
So, I mean, if you want to talk to him, you can. Otherwise, it'll be set for trial and we'll go to trial and the court will only consider a plea bargain agreement with good cause. Otherwise, you have to plea open to the court.
That's fine, Judge.
Okay. All right. So, Mr. Crenshaw, how long do y'all expect the trial to last?
4 days at the most. Yeah.
All right. Oh, sure. Come forward.
We'll pick up when they go back up to break. Right now, we are in a verdict watch for Adrian Gonzales. I have right at 1 hour. We are about 10 seconds away from 1 hour into the verdict watch. The jury will probably work through lunch, but probably just finishing up their lunch. Hopefully they were working during lunch.
All right, your next question.
Thank you. Ms. Singley, good afternoon.
Good afternoon.
You listened to Ms. Groff's testimony yesterday, correct?
Yes.
Did you hear her discussion of the position of Joe Ryan and the blood, whatever she called it, on Joe Ryan? Do you remember that discussion?
Yeah, you mean specific to his arm? Or is that what you're referring
Specific
to?
to his position on the ground.
Yes, I did hear her talk
Okay.
about that.
Did you agree with that?
That the blood stains would indicate that he was lying on the ground?
Yes.
No.
And what can you point to in your expertise that would have you arrive at that conclusion?
Well, so I guess starting with, I believe that she mentioned that the stains that were the 4 linear stains that I did not classify, she classified them. So that's where the first divergence was. So then that classification is what led her to say that he would have been in a position lying on the ground when they were deposited, if I recall correctly. So the first part is that as I mentioned before lunch, the target surface didn't lend to classification to start with, and to go on to then determine what that classification would mean in terms of his positioning is the part where it starts by the fact that I didn't believe that a classification could be made. Then to go on further to say what that classification would mean would be why I would disagree.
Okay. And was there evidence that you observed that would have supported different conclusions than that, other than not being able to classify?
So maybe the best way to describe this is to have you understand what a drip stain is in terms of bloodstain pattern analysis. A drip stain is a stain that is formed by gravity alone. So it's not just a circular stain you see on the surface. It's a circular stain that arrived by a passive formed by gravity. So it's not something that happened that's circular from another mechanism, but it just happened to hit the ground at perpendicular, making it circular. It is formed only through gravity alone. So the fact that I didn't classify it as anything was the first part. But then on top of that, if you have just the fact that something is circular does not make it a drip stain. It's one of the features you can look at, but it doesn't mean that it's a drip stain. So There are other mechanisms that when the blood is going through the air, say from an impact, say somebody was being beaten with a hammer. When the blood goes through the air, it goes in a parabolic arc. And if it doesn't hit anything in that trajectory, it will eventually fall to the ground. And when it hits the ground, it's going to look circular. But if it hits the wall on the vertical surface, it's going to look circular there too, because anywhere it hits a perpendicular, it will look circular. But we look at the size of them to kind of help to inform whether it could just be a drip stain, something that just was because somebody was standing over something and dripping blood, or if it was because of another mechanism. So because we didn't have a lot of these features, there was no classification done because the size helps to inform that. And then the shape itself and the fact that we had this target surface to eliminate any of those other mechanisms, to only say that these are coming from drip stains and coming from above was part of the problem. Going further, if they were drip stains, it doesn't mean that because his arm was this way that he was down on the ground. It just means that the arm was in a position horizontal to where the passive drop was coming. Because people move around, your arm can be in, your body can be in different positions when you do that. So the orientation of your body and where that is in relation to where the blood is coming from is going to be how it will look like on that surface. But it's hard to then say, oh, the person was in this position just because there's something circular here that I think is a drip stain, and therefore because it's coming from above, he has to be on the ground lying down.
And if you were, as you've indicated in your previous testimony, that you would need more information, what more would you need other than what you just said in order to even make the determination?
You mean what? I'm sorry.
Objection calls for speculation.
I'm just asking her what other tools.
Overruled, that's right.
Yeah, I think, I mentioned earlier, same answers as I would be looking at the size, shape, distribution, location, appearance. Those are the features that I look for and determine that this is a drip stain to the exclusion of all other mechanisms. I would want to look for something that would look perfectly circular, that I could see scalloping all around the edges or spining around the edges, or it's perfectly circular on, like, say, a smooth surface, and that it has some size to it that would indicate that it's coming from just gravity forming it. If it's tiny, then, and I see it in terms of other, maybe in terms of other spatter stains in that area, I'm going to presume it's coming from or classify it as something coming from a mechanism that's a spatter producing mechanism, as opposed to just a single passive drop. So sometimes we can't tell. I mean, we just have to look for those features and hope that if the target surface allows for it, we can classify it.
And in the absence of concrete information, is it appropriate to default toward
Objection leading.
Sustained is to leading.
In the absence of additional information you want, how does one resolve that?
You go back to the higher classification. So if we start at blood stain, and then we might go to a spatter producing mechanism of some sort, and then we can classify that either to cast off or impact or expirated blood. If we don't have the features to meet those on each level of that, we revert back to the level that's higher. And so in this case, I just said, these are blood stains, and I described them. They were irregularly shaped, somewhat three-dimensional on the arm.
Thank you. I have no further questions.
All right, cross-examination.
Good afternoon.
Hi.
So to stay with where we just left off.
Okay.
You're keeping it at the classification level that's up here because you don't have enough information to go a next step. Is that correct?
Yes.
But that doesn't inherently mean that that next step isn't a possibility, right?
Well, I don't consider the possibilities, because if I can't go beyond the classification, then I didn't go beyond the classification. There's a reason I stopped.
Sure.
So I wouldn't.
But because you stopped, that then leaves all of the options still available. None have been excluded, correct?
You mean every possible mechanism that could possibly produce a blood stain?
Yes,
Yes, I guess, yes.
yes,
Yeah,
including drops from above.
yes.
Okay, thank you. Going back for just a moment, you testified regarding the DLI lab, and you stated that the test sample was the pull from the genes avoiding staining. Is that correct?
I'm sorry, say that again. I
You
didn't hear that.
testified about the DLI DNA lab,
Mhm.
specifically that the sample was a swab or a portion of Joseph Ryan's genes avoiding staining. Is that correct?
Avoiding, yes, avoiding staining, yes, I'm
Okay,
sorry.
but did you also read in the report that that sample was positive for blood?
Yeah, so it didn't say it was positive for blood. It said that blood was indicated in the sample. And so what that means is that they did a presumptive test. So that's a test that,
Right, we heard about that from our DNA experts. but-
yeah, so we didn't, the blood wasn't identified in that sample. It was an indication that there was blood there. And I think to clarify that the testing that is used in that instance is a very sensitive test that can pick up blood that you
Judge, I'm
can't
gonna
see.
object. I don't think she's presented any foundation for knowledge of how the testing was conducted. And that wasn't my question.
All right, we're going to ask your question again. Let's go
Okay.
that way.
The laboratory result said that blood was indicated, yes or no?
Yes, that's not what you asked me though. You said it was found. It was, yeah, the test only said that blood was indicated.
Okay,
And yes.
thank you. That's all I have, Judge.
Okay, any redirect? Is this witness subject to recall?
Yes.
All right, so since you're subject to recall, just don't discuss your testimony with anybody, all right?
Okay, thank you.
Thank you.
Karen, if I can consult with counsel for
Yes.
just a moment.
I'm sorry.
The witness is not subject to recall.
Okay,
for
you
the-
are not subject to recall, ma'am, so you're free to go if you wish. All right, thank you. All right, your next witness?
Yes, thank you, Your Honor. Brendan Miller.
I thought for a second he was going to go Brendan Banfield. For a second, I thought that he was going to get up and testify.
I need like space for my paper.
Sir, or from to testify truthfully in this case under penalty of law. Thank you.
You don't have to go away. I can start my Miller notes.
Okay, a question was asked on the other live. What is the difference between blood being indicated and testing positive for blood? Wonder if the lawyer didn't ask a clarification on that. Yeah, that's a little different. Sometimes you can do what's called a preliminary test, and it can be an indication, meaning it may be blood. And then you have to go in and you have to take it in and have a more viable testing. You know what? That's a good thing. Let me see if I can look this up in my I have a program thing for legal stuff. Let me see. I'm going to just Google, not Google, but look up okay, so indicated means that it potentially could be, it's blood, but is it human or is it animal blood? I think that may be a part of it. So medically speaking, blood indication means screening or initial check suggests that something resembles blood. So it could be the color, it could be texture that they're seeing that's present. Screen testing is a phlebotomist type thing. It's very sensitive, but non-specific. It can also be, like I said, animal blood. It can be certain chemicals, plant materials, or even cleaning agents can falsely test positive for blood. So there's for the indication means preliminary reaction. So it's like they take a Q-tip and they swab that little, they dampen it, they swab the area, they put it in the thing, they flick it and it turns a color. That's indicative of blood, meaning potential blood. If it's a human, is it animal? They don't know. Then they take the blood to the lab and then they test it, and it is a confirmed actual human blood. Does that help you? Yes, I would have been right. Yeah, that's a good question.
Brendan Miller, Brendanmiller.
And where do you currently work?
Fairfax County Police Department.
In what capacity do you work in the Fairfax County Police Department?
I'm a detective in the child exploitation section.
Okay. During your, were you involved in this case as an investigator at any point?
Yes.
Okay, and what was your capacity as investigator?
I was the digital forensics examiner for this case.
And when did that change?
About a year ago.
Sorry, almost there.
That's not my computer.
In child digital forensics, do you utilize the same skills that you had when you were at digital forensics?
I do.
Okay. And so when you left digital forensics, did you leave of your own volition?
I did not.
And was the transfer to child exploitation?
Yes, the transfer was to child exploitation.
Okay. How long had you been in digital forensics prior to being transferred?
Since roughly 2019, so about 5 years.
Okay. And how long, how many cases had you handled in digital forensics prior to that transfer?
I don't recall the exact number.
Okay. Were you the person who did the digital forensics in the Fairfax County Police?
One of them.
How many others are there?
There were 6 at the time, I believe.
And now when you were transferred out, this was in the middle of the investigation of this case, correct?
I don't know if I would classify it as the middle or where it was.
It was during the pendency of this case.
Yes, this case was still going on.
Okay. And in your capacity as digital forensics examiner, I'm going to ask you to look at a document. Okay, do you see anything on the screen?
Just your screensaver.
Okay. My apologies, Judge.
That's all right.
Sir, can you see that on the screen?
Yes, sir, I can.
Okay. Do you recognize that?
I do.
Okay, and what is that?
That is an executive summary.
And this is an executive summary that you wrote as digital forensic examiner for the Fairfax County Police?
Yes.
Did you want to mark that as a?
Yes, Your Honor.
Exhibit.
85, please. Defense
85
Exhibit
for the
85.
record? Just thank you.
And sir, this is your personal digital forensics executive summary, is that right?
I created this document, yes.
Okay. And now, in arriving at these conclusions, this was related to your work as a digital forensic examiner, correct?
Yes.
Okay. Your Honor, I move this in as Defense Exhibit 85.
Any objection?
Yes, Judge, at this point in time, I think this would qualify as an expert report. This witness has not been qualified as an expert, nor has any foundation been laid for the report.
Okay, so foundation is the objection, so sustain that objection if you want to lay.
I can do that.
Sure.
So sir, tell me about your experience in digital forensics.
In what regard?
From the moment you got into digital forensics, what kind of training did you have?
I've received training in a variety of forensic tools and training specific to computer systems, specifically the International Association of Computer Investigative Specialists, IASIS. I've also been trained with Cellbrite, and I'm current in both of those certifications, and training with Magnet and X-Ways and various other forensics platforms.
Okay. And did you receive additional training beyond that within the Fairfax County Police?
I'm also certified for BERLO, which is the vehicle forensics. Various other trainings at different times.
Have you ever been qualified as a witness in the courts of Fairfax County?
Judge, I'd
I'm
object to the question.
qualified as an expert, I'm sorry.
Yes, I have.
Okay, how many times?
2 that come to mind.
Okay, and was that in your capacity when you were a digital forensic investigator?
Yes.
Okay. Your Honor, I move Detective Miller in as an expert in digital forensics.
Any objection?
No objection.
All right, so moved.
Now, sir, is this report the report that you created?
Yes, I wrote this.
And when was this report created?
I don't recall the exact date.
Okay. Was it prior to October 25th, 2024?
I don't recall exactly, but that sounds about the right time frame.
Okay. And that's a significant date because that was if I can remind you, the first recant for Juliana Perez Magalhaes. Does that give you a better idea of when this would have been done?
If memory serves, this was done prior to that.
Okay, that's all we can rely on is your memory. And Your Honor, I don't have any further questions.
All right. Yeah. Cross-examination.
I mean, Judge, I would note that, no, I have no questions at this
Okay.
time.
All right.
Those are all the questions, Judge.
Is this witness subject to recall?
Yes.
Okay, sir, since you're subject to recall, you cannot discuss your testimony with anybody. You do not need to stay here today, but just be on call for that, okay? You're still subject to the rule of witness, okay?
Yes, Your Honor.
All right, thank you. All right, your next witness?
Harry Lidsky.
Do you swear or affirm to testify truthfully in this case under penalty of law? Thank you.
Sir, can you please state your name and spell it for the court reporter?
Harry Lidsky, Harry, LID as in David, SKY.
And how are you currently employed?
I'm currently a private investigator and digital forensic examiner, self-employed at my company, 4DIS.
Okay. And what's your background in terms of digital investigations and investigations?
Prior to starting my own company, Fordis, I retired after 20 years in federal law enforcement, 7 years with the DEA, the Drug Enforcement Administration, the remaining 13 years with the U.S. Department of Justice, Office of the Inspector General. For the last 11 of those 13, I was in the Cyber Investigations Office, where I progressed as a senior special agent to the assistant special agent in charge and retired as the special agent in charge of that office. The Cyber Investigations Office handles, as the name would imply, digital forensic examinations. We're responsible for supporting the entire agency nationwide with mobile and computer forensics, basically anything with an on-off button, anything that was electronic in nature, is where our services were brought to bear. On top of that, we ran our own investigations, those specifically which were digital forensics centric.
And in terms of issues, have you ever heard of catfishing?
Yes, I have.
Have you worked within investigations where it's alleged or it's found to be catfishing?
Yes, I have.
So do you understand the elements necessary for catfishing?
I do.
Describe for the ladies and gentlemen of the jury what that exactly is.
It's a form of misattribution in terms of who's performing what activities. So at its core, it's somebody pretending to be somebody else, usually designed to lure somebody else to do something. It can be employed in a scheme to defraud. It can be employed to get somebody to show up, to get them in trouble, to get somebody to show up to an event they had not intended to show up at, to misdirect somebody to show up for something. A case that I worked, it was employed to misdirect somebody to show up who thought they were coming for a consensual sexual encounter, not unlike this particular case. And in fact, they were there to serve a different purpose, to be set up as a victim, as a utility or a tool in that particular investigation.
So in that particular investigation, was that from the prosecution side or the defense side?
That's when I was a criminal investigator, a federal agent for the Department of Justice.
Okay. Now, in terms of your investigative experience, even beyond digital forensics, can you tell the ladies and gentlemen of the jury what kind of experience and what kind of responsibility you had while being a federal investigator?
Well, in addition to the digital forensics, again, 7 years with the DEA, it was drug law enforcement, pretty straightforward, what you'd think, what you'd expect, I guess, between the street level version of it, domestically, always working our way up towards the source, back to the cartel sources and usually overseas. But through that, I gained experience with interviewing witnesses, interrogation of subjects, obviously arrest tactics and things along those lines. But there was also a strong money laundering component involved with that. There was surveillance skills were heavily employed during my time with DEA. I did a lot of undercover work with DEA. At the DOJ OIG, the Department of Justice's Office of the Inspector General, we were the watchdog for the Department of Justice. So we investigated both administrative and criminal waste, fraud, abuse type misconduct that occurred within the Department of Justice, that is, employees of the Department of Justice, or also from external actors affecting the business of the Department of Justice. And through that, we did a fair amount of investigations to the extent that makes sense. There was a number of high-profile investigations. Fast and Furious might be one of those, where our investigation was aimed at the investigation or the operation conducted by the ATF in that particular instance. And we would often find, we would make assessments, recommendations, and even punishment recommendations for employees that acted either out of malice, ignored or abused policy, whether they engaged in misconduct inadvertently or maliciously, those were the type of findings we would have. So if we found that an investigator failed to adhere to policy, we might have a finding. If we find an investigator lied to us, or in an investigation, somebody within within the purview lied to us, we would find they lacked candor. So we, our reports, our investigations resulted in terminations of employees. Sometimes they were.
Judge, at this point in time, I think we've launched into a narrative that is not responsive to the question, nor is it relevant.
All right, if you want to ask the next question.
Well,
Continue on that.
It was a question about your investigative background, so please continue.
Yeah, so that was the gist of what we did. So it's pretty broad spectrum of investigative experience. That added component from the OIG of having the investigative oversight and being the watchdog to include over investigations and other police officers, other federal agents, other prosecutors, was a nuanced twist, I suppose, in my experience there. In addition, there was the more traditional, straightforward investigations we conducted, to include everything from white collar, bribery, catfishing, international money laundering, conspiracies, and the normal type of white collar crime.
And in terms of your investigating the investigation, you were actually dealing with law enforcement people who came.
Objection leading.
All right.
Explain what you did in terms of the investigation of the investigations.
Sure. DOJ is huge, the biggest law firm in the world, as we like to say. DOJ includes the FBI, the DEA, the ATF, U.S. Marshal Service, Bureau of Prisons.
DOJ means Department of Justice, all the agencies he's listing.
U.S. Attorney's offices, Interpol, and about 40 other smaller components, tax division, civil rights division. So we were a massive agency far and wide. So we were made up of federal agents, FBI, DEA, ATF, and marshals. But we were also made up of attorneys. We were made up of auditors. We were made up of all sorts of employees. We had IT employees engaged in inappropriate network activity where they were reading other employees' emails improperly and illegally. So whenever somebody was accused of misconduct, whenever an allegation of misconduct came our way, we would take that on. So it can take all forms.
Now, going back to the digital forensics investigations, you indicated you were there for 11 years?
Yes, sir.
Okay. And during that period of time, were you ever qualified as an expert in the court of law?
Yes, I have been.
Okay. How many times?
I'd say 3 or 4 at the federal level, and once since retirement here in the Commonwealth.
Okay. Your Honor, I'd move Mr. Litsky in as an expert in the fields of digital forensics and general investigation.
All right.
Judge, I'm not familiar with general investigation as an expert field, but certainly digital forensics we would accept.
I'll move him in as for digital forensics expert.
Yes.
Okay.
Sir, you became involved with the Banfield case. What was the first thing that you did when you started reviewing evidence?
The first part of my evidentiary review focused on the digital forensics. I was provided with a rather large, volume-wise hard drive, 8 terabytes, I believe.
And the digital forensics, and I guess, Your Honor, I would just state that the digital forensics that are the foundation have all been stipulated to in the stipulation document in terms of
In terms of a report of a digital.
in terms of the data that was taken from the devices.
Yes, Your Honor. We have stipulated that the raw data pulled from the devices does not need to have a chain of custody or
Okay.
foundation.
So he can talk about the raw data from the devices. Okay.
Yes. And so, sir, what's the first step in your analysis of digital forensics when you get involved in the case?
Well, in this particular case, it was atypical because I didn't have to perform any of the acquisition phase of it. Detective Miller had already performed all of the digital forensic acquisition. So what I was provided was generally the derivative elements of his work, which allowed me to just jump right in and review the various artifacts. When I'm performing a digital forensic exam that's derivative of somebody else's work, I make it a point not to review their findings. The reason being, digital forensics is somewhat analogous to solving a big math problem. So to perform it accurately, or at least the way I like to perform it accurately, I like to do the work myself, see what answer I come up with before I see the answers of somebody else's work. Digital forensics is a science such that we're all trained similarly. We all take the same training. We all operate the same way. If we perform our actions as we should under the guise of best practices, we should do the same thing, each one of us, and come up with the same results. Digital forensics is repeatable. Digital forensics, it should be, it's binary. The data is the data. It's not subject to interpretation. It's not subjective. So what you see is what you get. There are nuances in understanding it and what it means. Assigning attribution is a different phase of it, but and we'll eventually get past this boring stuff and see some of it. It does reveal what's going on behind the screen, typically on either a phone or a computer.
Now, in terms of the digital forensics in this case, how do you arrive at certain conclusions?
So digital forensics, like most of the forensics, and we've heard a fair amount here so far in this trial, it's supportive. It can be informative. You can draw certain conclusions, but they're based upon the results of the digital forensic analysis and its impact on other items of evidence or other items of investigative nature. And what I mean by that is, for example, if somebody says, if we're investigating a crime that took place in Boston, and somebody says, I have an alibi, I was in Miami, and I look at their phone and there are artifacts that reveal location information in Miami, that is an informative piece that says this individual, based on their phone, might have been in Miami at the time. Now, phones can travel without, are traveling with them. So was the phone there? Was the person there with the phone? So that's a lead. That's a pointer. The follow-up to that would be, okay, do we have airline records? Do we have video surveillance from an airport? Do we have video surveillance from a hotel in Miami? Do we have credit card transactions from a restaurant in Miami? Other indicia of location. So digital forensics is informative. I guess if there's enough digital forensic pointers that can, I think pass a test, then it can be conclusory as well, and we can draw conclusions from it.
And in your example of something in Miami, when you arrive at a certain number of artifacts that say the person's in Miami, is that it?
It can be. That's probably a bad example in terms of being conclusory. If somebody says, there's no pictures of a red sports car on my phone, and I find 100 pictures of Ferraris that are red, that's conclusory to say that the witness information or the interview subject information that they provided to the investigator, whether it was me or somebody else, is clearly wrong. Now, that doesn't get to whether they misremembered, whether those photos are old, whether they were taken by somebody else. So there's still an attribution aspect, but it can be conclusory or informative in that regard.
Okay. Now, in the context of this case, what were you trying to determine based upon the theory of the Commonwealth in this case?
So this case, I've the luxury of coming in at after things had developed. The theory had already been assigned. Catfishing was already Mr. Banfield had been charged already. and indicted under a catfishing theory when I was brought in. So that was my immediate focus. So confirm or refute that theory. As as an investigator, whether I'm in my law enforcement capacity or now my private capacity, the facts don't change. The facts are the facts. Facts don't take sides. The truth doesn't take a side. So for me, just because I'm hired or asked to investigate one particular theory, it doesn't mean.
Judge, I would object at this time. This is non-responsive.
All right, I'll sustain as non-responsive.
Okay.
You don't ask your question.
Sir, in terms of what you did when you started this investigation into Christine Banfield's devices, what did you do?
So I started evaluating the devices, but at the same time, I reviewed other evidence that was available to me provided in the discovery. That would include witness interviews. That would include subject or co-defendant interviews. That would include social media type event like email, Instagram, Facebook, things of that, WhatsApp. So it's not all a device centric. It can be evidence provided by a service provider like Google or Apple. I reviewed all the photos from the crime scenes, the autopsies, the digital, the forensic science and Office of Medical Examiner. I reviewed all of the facts available to me. The best way to perform what I do is through all source
Judge,
analysis.
objection, non-responsive.
I sustain the objection.
Okay. So in terms of the items that you were just telling the jury that you review, did there come a time where you were reviewing and were able to arrive at conclusions?
Yes, I was.
Okay. And specifically, what date range or what period of time were you looking at?
So the window of time was from January 9th, 2023, specifically with regard to the catfishing, was from January 9th, 2023, obviously through the time of the event on February 24th, 2023. It did extend back a little bit further. For example, the discussion about the windows, that dated back prior to January 9th. There was witness testimony or subject interview, transcript information about planning that predated January 9th. So I don't just look at it at a time for digital forensics. It's important to look backwards for a certain relevant period to ensure that
Objection, non-responsive.
Sustain the objection.
Why would you look backward in a digital forensic analysis?
A single artifact, as we refer to them in digital forensics, it may not be informative, right? A single text message on this day may lack the context, but the 50 prior exchanges might help that context, right? That's relatable, and the communication after that might also help inform. So it's important to look backwards. It's also important to look forwards in digital forensics. And when we're talking about, in this case, the allegation of a conspiracy that lasted a period of months, I find from an investigative perspective that it's important to look at everything. Digital forensics, like any, I think, informative piece of evidence, should.
Objection, non-responsive.
Sustain the objection.
In the context of certain behaviors that come up through the investigative process, like, for example, when someone may have had their phone and their laptop and when someone would have been away from that, are those things that you look at?
Especially for events like that, what was happening immediately before the event is vital in determining attribution or who might have been performing what activity on a device.
Or in saying it in another way, would there be
Objection, leading.
I haven't heard the question yet.
what would you do if there was a pattern of time that needed to be analyzed, or a time of day, or a certain day? How would you go about doing that?
Well, with the digital forensic tools that we have, the software that we have, we're able to visualize things in a timeline fashion. So I'm able to look at, or folks in my profession are able to look at what happened, both what the user was doing and what the system was registering, the computer system. So we're able to generally create a granular timeline that helps inform a decision or conclusion about whether a device might have been removed, from one person and used by another.
Okay, now can you see the document that's on your screen?
I see Detective Miller's executive summary.
Yes.
Yes,
Have you had an opportunity to review that?
I have.
Your Honor, can that be published to the jury?
It was not admitted into evidence.
Okay, I'd move it into evidence. as
Objection,
Exhibit
Judge, it's a
85.
hearsay document at this time.
I'll sustain the objection at this time.
Detective Miller testified to it.
If you want to approach.
We have a sidebar. Wake up, everybody. Wake up, little Susie. Wake up. Wake up, everybody. Yeah, this is a sleeper case. This is what I call a sleeper case. That's some interesting forensic stuff.
Mr. Litsky, I'm going to go to,
He lost.
sorry.
Regroup. Yeah, that threw a bunch of his questions out of the water. That was a good win for the prosecution. Just saying.
Can you see something on your screen there, sir?
I can.
Okay. There's evidence in this case regarding window replacement that was communicated by Juliana Perez Magalhaes. Do you remember that?
I do.
Did you do a digital examination? Did you do a digital examination as to the allegations that she made with regard to window replacement?
I performed searches relating to that particular topic. I'm able to perform keyword searches as one of the search criteria. So I did perform searches related to that particular part of testimony, yes.
Okay, and was this part of the information that you'd received from our discovery and the data that came from the devices?
Yes, it is.
Okay. I'm going to have you look at the document that's on your screen. Can you, Your Honor, I'd identify this as Exhibit 86.
All right.
Can you look at Defense Exhibit 86 and explain what we're looking at here?
Judge, I'm going to object to any statements regarding what's contained in the document.
Are you moving it into evidence, Mr. Carroll?
Yes, Your Honor.
Any objection?
Yes, I would object to foundation. We have not been given any information about this
Sustain as
document.
to foundation, if you want to lay a foundation.
Sir, how did you find these documents and what processes did you use in order to find this information?
So based on the derivative evidence provided to me in discovery on this case, I analyzed, in this particular one, this came from Ms. Banfield's cell phone.
Judge, I'm going to object to that conclusion. Again, there's been no foundation laid, and we can approach and I can explain further.
Here, you want to approach?
Prosecution is on it and she is nailing them. Wow. This is going to get good, y'all, because if he loses this, he's losing a lot here. And they're in the defense's case in chief. So this is the defense's to win or lose at this point is on them. And if she denies this, that'll be the second piece of evidence that does not get in. And that must be very frustrating for this attorney. But boy, this prosecution is on the ball.
What was the raw data that you used in order to get this? And
moved on. He lost.
To arrive at this.
This was from an Axiom portable case created by Detective Miller. An Axiom portable case is a derivative product from Magnet Axiom for digital forensic software, which performs mobile and computer device review, or facilitates mobile and computer device review and cloud review and all things digital. So the software is baked in. It's an executable program that comes from the main Magnet program. So Magnet permits digital forensic examiners, in this case Detective Miller, to create a derivative subset of his work that is able to be open on any Windows computer. So you don't need to have a software platform. It is a software platform.
And if you can tell the ladies and gentlemen, the juror, or Your Honor, we move that in as comes or
Same objection. If we could approach, please.
Another sidebar. Wow. He's going to have a hard time with this prosecution putting his case forward if she keeps doing this. I mean, this is what, third sidebar in less than 10 minutes? Y'all, we should have a sidebar counter if I could figure out how to do it. Oh, as soon as this is over, I have got a ton of stuff to get done to get ready for this winter mix that's coming. If you were in the path of this winter storm, be careful, stay warm. It is 68 degrees. It'll be low in the 40s today and tomorrow, Friday. So our bad nights are going to be Friday to Saturday night, Saturday to Sunday, Sunday to Monday. We're going to have snow on Sunday, 55% chance of snow. Saturday, we're going to have ice. Friday, we're going to have rain. And that's going to suck a duck. Big time. So I've got to start getting stuff together. I'm going to pre-cook some food. So if I have to, I can cook on the grill. I'm going to pre-cook a bunch of food that if I need to and the power goes out, I have a grill outside that is propane. And it's got air fryers in it, and it's a griddle on top. So I am prepared, y'all. I was prepared. Yes, I is. I was prepared. I was prepared, y'all. I've got to get some stuff moved around and cleaned up. So I got a lot to do before the storm hits. Also got to get all my clothes ready, get all my emergency gear ready. Because believe it or not, I get called out a lot. I go out a lot during these storms because you have a lot of people that get injured. So I go out a lot. Would be nice if I didn't have to, but I do. We do. Miss Lady died in the house. Let me pause it. Miss Lady died. Diana. Let me get her on screen. Hello, Miss Di. Okay, y'all over here y'all over on this side don't see her. We got two lives going right now. We got one that is in a verdict watch for the Adrian Gonzales, And then we have this one over here, Lady Di. I'm going to mute her while she has a fit. She's dropping stuff over there, y'all. Miss Di, are you going to interpret? Are you going to interpret? It's up to you, boo. I ain't. I'm hurting. Well, it's all the arthritis. Are you going to get ice and snow over there, Miss Diane? She said, nope. We is. Northern parts of Carolinas are. Pennsylvania, Tennessee. Oh my gosh. Well, Diane, we can't talk down, but we do need to talk this evening. All right, I'm going to turn this back on. We got people waiting on both ends of the boat. Okay, we are still in the sidebar. Diane should have just painted her wall black.
Sir, did you work with the raw data that was provided by the Fairfax County Police through search warrants and other providers, things like that?
For search provider, for service providers, yes. The records I had were responsive from Google, Apple, Facebook, and Instagram, FetLife, and others, Discord. For the computer and mobile devices, I was not provided the raw data. I was provided the derivative work, the portable cases, the Celebrate readers, which to my understanding, is the complete device. Nothing is filtered out, but I wouldn't characterize it as raw data.
Your Honor, may I just request a 10-minute recess?
We want to do our afternoon recess? We can do that.
Yes.
Okay, let's go ahead and take our afternoon recess for 15 minutes, ladies and gentlemen. And we will get right back to you. Again, don't do any outside research. Okay.
Yeah. Correct.
Okay, Miss Lady Di. Yeah, you I saw your friend. We are in watch on both sides. We got on this side, I got 2 lives at one time. I'm thinking about shutting one down and putting us all on one and doing verdict on watch on one. June, go to private chat and Gonzales and tell me, do you agree with me to just close down the Gonzales for the day? Or should we leave up both lives? We can have Gonzales up on the, we can, when the verdict comes in, we can pop it up over here on the Brandon Banfield. Let me know what your humble opinion is. We do have a poll up. If you were on the jury, how would you find Adrian Gonzales guilty? 25%. Shockingly, 75% not guilty, 0 hung. Interesting poll. Hello, Spin Steer. Hello, beloved. How are you doing? Don't forget to stock up on toilet paper, girl. My sister passed away and she had so much toilet paper and paper towels, trash bags, Ziploc bags. I am good to go. Arizona is nice at 65 degrees. Come summer, though, we're hurting, guaranteed. I love that kind of weather. Diane said her sister says when Mama passes, she wants to move back to Alaska. No. Yeah, anybody who's got health issues should not move to Alaska. Hello, it's been Steve. Do I have a mod to respond to me in private chat, please, or whether or not we want to keep the Adrian Gonzales still going and have 2 lives, or if we want to combine everything in over here on the Brendan Banfield. It's a lot to keep both of these going. Huh? Well, it's a lot on my system. People don't realize it takes a lot of your memory to run lives. And when I have 2 lives running, plus Discord, plus both chats are popped out, plus I got the calendar up and going at all times because you never know when I need to pop calendar. Then I have my main feed going, so I can see what my output is. It's a lot on a system. It's like running 3 full gaming things at one time. Hence why I got a kick butt gaming system. Hello, everybody. Diane wants to know how my kitty's doing. They're doing good. I'm going to put the sound on this one. Hold on.
In the context of this case, what were you trying to determine based upon the theory of the Commonwealth in this case?
So this case, I've the luxury of coming in at after things had developed. The theory had already been assigned. Catfishing was already Mr. Banfield had been charged already and indicted under a catfishing theory when I was brought in. So that was my immediate focus. So confirm or refute that theory. As an investigator, whether I'm in my law enforcement capacity or now my private capacity, the facts don't change. The facts are the facts. Facts don't take sides. The truth doesn't take a side. So for me, just because I'm hired or asked to investigate one particular theory, it doesn't mean.
Judge, I would object at this time. This is non-responsive.
All right, I'll sustain as non-responsive.
Okay.
You don't ask a question.
Sir, in terms of what you did when you started this investigation into Christine Banfield's devices, what did you do?
For the sake of my computer system, we're going to put everything in one feed. We're going to go ahead and close down the Adrian Gonzales feed. However, we are still on court watch, and we will break in on the Brandon and Banfield trial when the Gonzales trial, if they go into a verdict today. So I'm going to close out that feed. We're going to combine everything into one. Miss Diane, don't go anywhere. Mods, if y'all want to hop over to the band field, that'd be great. So everybody, thank you so much for following us over here in the Gonzales. It was a wonderful, wonderful day with you. Come join us over at the band field. Greatly appreciate it. In the meantime, we'll see you tomorrow morning. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.